Please tell me your name. Oh, I'm sorry, hold on. I don't have the interpreter. It's Monday.
Good morning, Your Honor. This is Alan Figueroa, State Certified Spanish Code Interpreter.
Has the interpreter been sworn?
Yes, Your Honor.
All right, please connect with the headset.
¿Me escucha?
Good morning, sir. Please tell me your name.
He can hear me, Your Honor.
David Rivera Mercado.
David Rivera Mercado.
21 CF 11781. You're here charged with false imprisonment, domestic violence, and battery domestic violence. There is probable cause here. I'll appoint an attorney to represent you.
Okay.
Okay.
Your bond is going to be $15,000 on count one, $100 on count two. You can have no contact with a victim. Do you understand what no contact means?
Sí.
Yes.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. You can have no contact with a witness in this case. You can have no unsupervised contact with any minor child under the age of 18, and you must comply with any plan set in place by DCF. Good luck, sir.
Thank you. And Your Honor, just for the interpreter, confirm the case number you said was 21 CF 11781.
Yes.
Thank you.
Please tell me your name.
Mayra Asensio Montañez.
Myra Asensio Montañez.
21 6121. You're here charged with battery domestic violence. Battery dating violence. I'm going to appoint an attorney to represent you. There is probable cause in this case. Sir, do you wish to testify, and do you need an interpreter?
I don't need an interpreter.
All right, do you want to testify today?
Yeah, I had something to say.
Please raise your right hand.
Swear to tell the truth, the whole truth, and nothing but the truth.
I do.
May I inquire?
Go ahead, state.
Good
I
morning,
do-
sir. Can you please state your name for the record?
My name is Isaiah Rivera.
And can you please spell your last name?
Rivera.
Thank you. And what is your relationship to the defendant?
I'm her spouse.
Okay. And are you afraid of her?
No.
Has anything like this ever happened before?
No.
Do you believe drugs or alcohol were involved in this incident?
I'm sorry, could you repeat?
Do you believe drugs or alcohol were involved in this incident?
Not at all.
And do you want to have contact with her while this case is pending?
Yes.
Thank you. Is there anything else you'd like to tell the court?
Yes, I just wanted to say what happened was something that we both could have handled better. I really don't want to move forward, but I know you guys don't deal with that right now. I don't want to move forward with anything. I've already made arrangements for two things to happen. Either we're gonna attend counseling, both of us together to get past this, or I've already also made arrangements if she doesn't want to move forward with that. Her parents are ready to take her to Puerto Rico, etc. But again, I think we can move past this. This is something that we could have both handled better, and I would like for if they could let her go today. We got two kids. One, she needs to breastfeed, and I just want to move forward with this. We both could have handled this better, and again, I just want to move past this. She's a good mom. She's an excellent mom, and things like this is a first-time thing, and I think this is something that we could get past.
All right, thank you, sir. I appreciate your time. Let me ask the defense if she has any questions for you. Does the state have any objection to PTR?
No, Your Honor, given the victim's testimony here today.
Hold on. All right, ma'am, at this time, I'm going to place you on pretrial release with special conditions based on the testimony this morning. I will allow you to have peaceful contact with your husband. Do you understand what peaceful contact means?
Yes.
No hostile contact, no yelling, no throwing things, no shoving. You can't possess a weapon, firearm, or ammunition.
Good, yes. Oh, sorry.
That's for her.
Okay.
You just can't hear the interpreter because he's speaking into directly into the headset. Are there any other conditions the state would request? All right, good luck, ma'am. Thank you, sir, for your time. Good luck. Can you have him come back in for 1 second? Can you come back in? I didn't say this, but you said you were hoping she would be released today. She should be released at some point today.
Okay,
I just want you to be aware.
thank you.
All right. Please tell me your name.
Jaime Millán. Jaime Millán. Sí,
Jaime Villan.
Spell your last name.
Millan.
Millan.
All right, good morning. You're here in 21 MM 6117, charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Ma'am, do you wish to testify this morning?
Yes,
Do you need an interpreter?
yes.
Could I have the interpreter disconnect from the headset?
Sure thing, Your Honor.
Thank you. I have a witness here. All right. Ma'am, raise your right hand to be sworn.
Señora, levante la mano derecha.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
¿Jura decir la verdad y nada más que la verdad?
Sí.
Yes.
I'm going to allow the prosecutor to ask you some questions.
Bien, la fiscal le va a hacer una serie de preguntas.
Okay.
Good morning, ma'am. Can you please state your name for the record?
Buenos días, señora. Diga su nombre, por favor.
Liliana Álvarez.
Liliana Alvarez.
And can you please spell your last name?
Me deletrea su apellido, por favor.
Alvarez.
Alvarez.
Thank you. And what is your relationship to the defendant?
¿Cuál es su parentesco o relación con el acusado?
Somos esposos.
We're married.
Are you afraid of him?
¿Usted siente temor de él?
No.
No.
Has anything like this ever happened before?
¿Algo parecido a esto ha ocurrido en el pasado?
No.
No.
Are you willing to call 911 if anything like this ever happened again?
¿Usted está dispuesto a llamar a 911 si algo como esto se repite?
Sí.
Yes.
Do you believe drugs or alcohol were involved in this incident?
¿Cree usted que el alcohol o las drogas tuvieron algo que ver con este incidente?
No.
No.
And do you want to have contact with him during the duration of this case?
¿Y desea usted tener contacto con él mientras esté el caso vigente?
Sí.
Yes.
He qualifies for what the judge previously said was pretrial release, meaning that he potentially could get out of jail without paying a monetary bond. Is that something that is okay with you?
Él puede que reúna los requisitos, como había indicado la jueza, para la libertad provisional, lo que significa que puede salir de la cárcel sin tener que depositar una fianza monetaria. ¿Usted estaría de acuerdo con eso?
Muy de acuerdo.
I'll be okay with that.
Thank you. That's all I have, Your Honor.
Anything from the defense? All right, at this time, sir, I'm going to place you on pretrial release
Bien, señor, en este momento se le concederá la libertad provisional
and require that you post a monetary bond of $100.
y le requeriré depositar una fianza de $100.
At this time, you can have no contact with the victim. Do you understand what no contact means?
En este momento se le prohíbe el contacto con la víctima. ¿Sabe lo que eso significa?
Sí, señora.
Yes, ma'am.
You can have no unsupervised contact with any minor child under the age of 18.
No puede tener Contacto sin supervisión con ninguna persona menor de edad.
You can't possess a weapon, firearm, or ammunition.
Se le prohíbe la tenencia de un tipo de arma, arma de fuego o municiones.
You must comply with any plan set in place by DCF.
Y debe cumplir con cada condición que le imponga el Departamento de Niños y Familias.
You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings.
Debe buscarse otro paradero y se le permitirá regresar una sola vez junto a las autoridades para recoger sus pertenencias.
Good luck, sir.
Buena suerte, señor.
Thank you, ma'am. Do you have a question?
Sí.
Gracias, señora. ¿Tiene usted alguna pregunta? Yes.
¿Por qué no puede volver con nosotros?
Why is he not allowed to come back with us?
After reading the affidavit, ma'am, the court is concerned with the facts that are alleged therein.
Después de leer el affidavit, señora, el juzgado tiene preocupaciones e inquietudes basado en los hechos que constan en el affidavit.
Chiefly, that your 9-year-old son witnessed him hit you with a stick.
Principalmente el hecho que su niño de 9 años presenció a él golpearlo a usted con un palo.
The child said he didn't see you hit him at all.
El menor dijo que no lo vio, que no la vio a usted golpearlo a él.
Law enforcement stated that they saw marks on your body consistent with the 9-year-old's statement.
Y las autoridades indicaron que encontraron
And you refused to let law enforcement take pictures.
lesiones en su cuerpo que concordaban con lo que había dicho el niño de 9 años y usted se rehusó a que le tomaran fotografías.
At this time, because of those facts,
Dado esos hechos,
the court thinks it's probably in both of your best interests to have no contact with each other.
el juzgado cree que sería lo mejor para ambos no tener ningún tipo de contacto.
¿Puedo decir algo?
Can I say something?
You can say anything you want.
Usted puede decir lo que quiera decir.
Mi hijo de 9 años, él no vio nada, él repitió lo que escuchó de mí. Él estaba dentro de la casa con nuestro bebé.
My 9-year-old son didn't witness anything. What he said was basically he repeated what I had told him. He was inside the house with the baby.
Tengo que dejar en claro que mi hijo mayor es mi hijastro. Yo estoy con él desde que tenía 4 años.
And I have to clarify that the oldest, he is my stepson. I've been with him since he was 4 years old.
Mi esposo es un gran hombre
My husband is a great man.
y todo fue una confusión. Es primera vez que esto sucede.
And everything was just a confusion. This is the first time it has ever happened.
Y él no me hirió directamente con la intención de herirme.
And he didn't strike me directly with the intention of hurting me.
Por eso en ningún momento quise poner cargos y por eso estoy aquí.
That's why I didn't want to press charges, and that's why I'm here.
Y sí, y de verdad lamento mucho que tengamos que guardar distancia porque sus hijos y yo queremos que esté con nosotros lo más pronto posible.
And I regret that we have to keep our distance because both his children and myself, we want him to be as close to us as soon as possible.
I understand, ma'am. I thank you for your statements and for coming here today.
Le entiendo, señora. Le agradezco por su testimonio y por estar aquí presente hoy.
Unfortunately, however, none of the things that you told the court have assuaged my sense of concern for you and the children.
Pero desafortunadamente nada de lo que usted me ha dicho me ha borrado esa inquietud, las preocupaciones ni hacia usted ni hacia sus hijos.
So at this time, for today, my order stands.
Así que por el momento, hasta hoy, mi orden se mantiene tal cual.
His attorney can file a motion in front of the trial judge at any time, and that judge can modify my order.
Su abogado puede radicar un pedimento en frente del juez que será asignado al caso y ese juez puede cambiar o modificar mi orden en cualquier momento.
Good luck, sir. Good luck, ma'am. Thank you for coming.
Buena suerte a ambos y gracias por venir.
Please tell me your name. Oh, hold on, we're going to try the headset again. I don't know if we have a witness in this case.
I believe he's the Creole interpreter. Is that correct?
This one is?
No, this is
Please tell me your name.
Oscar Orlando Arias Mejía.
Oscar Orlando Arias Mejia.
21MM390, you're here charged with battery and sanitary nuisance. I'm going to appoint an attorney to represent you. I had a question about the second charge, Ms. May.
Yes, Your Honor.
Oh, I see. Never mind. I don't have that question anymore.
I didn't want me to say it in open court.
No, it's okay. I don't have that question. All right, sir, there is probable cause. Your bond is 500, no. Your bond is going to be $5,000 on count one, $100 on count two. You can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon, firearm, or ammunition.
No.
You can't be within 1,000 feet of the victim's residence or place of employment.
Okay.
Good luck, sir. Feedback. Please tell me your name.
Okay, Eliasar Nafate. Eliasar Nafate.
Eliasar Nafate.
21 CT 5996. You're here charged with operating a motor vehicle without a valid license and driving while license suspended. I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $500 on count one, $500 on count two. You cannot drive without a valid Florida license. Do you understand?
Yes.
At this time, I'm revoking both of his out on bond cases.
I'm not sure.
¿Dónde puedo pagar mi
Pulling it up
fianza?
in my system. Is it showing?
He's not represented by you guys. He has a private attorney in both of those.
Okay, I just wanted to make sure.
Yeah, you don't represent him. Sir, you need to contact your attorney right away. Do you understand?
Okay.
Okay.
Good luck. Please tell me your name.
Mixi Gómez Rebeco.
Mixi Gomez Rebeco.
21 CF 11774. You're here charged with using an anti-shoplifting. I don't think that's right, but control device. And petty theft, retail petty theft. I'm going to appoint an attorney to represent you. There is probable cause.
Yes, Your Honor, when setting bonds, they would just ask that you take into account, I believe she was visiting from Chile.
Yeah, it shows that she has no ties to the area.
Yes, Your Honor.
There's a co-defendant. It's a pretty sophisticated shoplifting. All right, at this time, your bond is $5,000 on count one, $100 on count two. You can have no contact with the co-defendant or any witness in this case. Do you understand what no contact means?
Not quite.
You can't speak with the co-defendant or any witness. You can't send them a text message. You can't call them on the phone. You can't send a message through social media. No contact.
Sí.
Yes.
Me habían dicho que la fianza era de $2,200, ¿por qué ahora es de $5,000?
I was told that the bond was going to be $2,200. Why is it $5,000 now?
I changed it based on the facts and the fact that you have no significant ties to the area. And there's no information here about what you're doing here and how long you're staying. Based on those facts, I raised the bond amount. You can't return to the premium outlets on International Drive for any reason.
¿Y qué pasará conmigo ahora?
And what's going to happen with me now?
So if you're able to post the bond, you can bond out, and then you just have to make sure that you're here for all of your court dates. If you don't post the bond, then you'll stay here until your next court date.
¿Y no me pueden bajar la fianza para poder pagarla porque no cuento con ese dinero?
Can the bond be reduced so I can pay it? Because I don't have that kind of money.
It will not be today, but your attorney can file a motion for bond reduction in front of the trial judge.
¿Cuándo veré al abogado?
When will I see my attorney?
Call the number on that paper and ask to speak with the attorney assigned to your case. No, the green piece of paper. The green one.
Okay.
Good luck, ma'am. I believe that's all I have for interpreter cases this morning. Thank you.
Thank you, Your Honor.
Oh, 21MM 6128. Ms. George, I'm going to appoint your office.
I'll waive the appearance, Your Honor. I'm gonna ask for pretrial release in this case, Your Honor. He has no criminal history.
What says the state?
Your Honor, state we just asked for bond with PTR, given that as a battery and an assault, and given the victim's not here to testify due to being taken to the hospital.
Your Honor, he's a student, no criminal history. I think that if he was on pretrial release, if it appears he was on drugs, random drug street, that would be sufficient in this case.
What's the relationship between the victim and the defendant?
I believe it's his parents, Your Honor.
Yeah, that's what I'm.
And if you look at it, he's not working, he's a student now.
All right, here's what I'm going to do. I'm going to place him on pretrial release, but require that he post a monetary bond, and I'll reduce that amount on count 1 and 2. It'll be $100 each. Actually, first I'm going to have him screened for mental health pretrial release with the same dollar amount for the bond. If he doesn't qualify for that, then pretrial release with the bond, but all the same conditions. No contact with the victim or any witness in the case, no weapons, firearms, or ammunition. Cannot possess or consume any controlled substance without a valid prescription. Did I say no weapons?
Yes, Your Honor.
Okay, that's it. And witness. On each count. Right. And pretrial release. So I'm not changing the amount. Rebecca? You'd be happier about that. Never mind.
Mr. Gordon is going to be behavior.
All right, 21 MO 998. Ms. George, I'm going to appoint your office. You want to bring him back tomorrow?
Yes, Your Honor.
I'm just looking at the charge. I understand it's behavior, but,
Yes, Your Honor.
all right. Sorry, what? You're going to do what with it? Okay, all right. We're going to bring this one back tomorrow. It doesn't matter. You're right, they're going to do whatever.
How you doing, Your Honor?
Good, please tell me your name.
Robert Francois.
All right, you're here in 21 CF 11779, charged with false imprisonment, domestic violence, battery, domestic violence, and sexual battery on a person 18 years or older. I'm going to appoint an attorney to represent you at this time. There is probable cause. Ma'am, do you wish to testify?
Yes.
All right, please raise your right hand and you look at me.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
I'm going to let the state ask you some questions.
Good morning. Can you please state your name for the record?
Naima Christian,
And can you please spell your last name?
Christian.
Thank you. And what is your relationship to Mr. Francois?
It's my fiance.
I can't hear you.
My fiance?
Thank you.
Are you afraid of him?
No,
Would you be afraid of him if he were to be released from jail today?
no,
Has anything like this ever happened before?
no,
Are you willing to call 911 if anything like this ever occurred again?
yes,
Do you believe drugs or alcohol were involved in this incident?
no,
And do you want to have contact with him during the duration of this case?
yes.
Okay, thank you. That's all I have, Your Honor.
All right, thank you. Anything from the defense? All right, thank you, ma'am.
I do want to say something.
You can say anything you want, but I just need you to get closer to the microphone so I can hear you.
I do want him home. This has never happened with us before. We are first-time parents, and I think that due to all that stress from being first-time parents, this altercation happened. The sex was consensual, and we have a 1-year-old son that we need to be together as a team to take care of. And and my son is missing him at home. And I do need his guidance and his help at home.
All right, thank you, ma'am.
I would ask that, given the testimony here today, that the sex was consensual, that you take that into consideration in setting the bond amount in this case.
Does the state wish to be heard on bond?
Yes, Your Honor, I understand the victim's testimony here today. However, also the allegations that are within that affidavit would state otherwise. So I ask that you take that into account as it is in the four corners of the affidavit. I believe during the end of the officer's time on scene, the story started changing a little bit. But given that it is an F2, he is entitled to bond on that charge. So state would ask that you set a reasonable bond. However, given that he is out on bond, state would ask that you revoke that.
And Your Honor, I would ask that you not take your alcohol license suspended, charge, or the fact that you are inclined to revoke in double. They were in a relationship, the victim just testified that it was consensual. So I just ask that you take all of that into consideration along with the fact that it's showing, I think the last victim in 2017. So just ask that you take all of that into consideration.
Regarding that, he does have two 2 prior failure to appear, and it looks like violations of PCR conditions
Your Honor.
as well,
We'll just talk about the facts. And that was all the way back in 2006.
as well as other probation violations, showing an inability to comply with court orders.
Your Honor.
Sir, I want to make sure you understand, you can say anything you want, and everything you say is being recorded and can be used against you later. Do you understand that? Raise your right hand to be sworn.
You sure to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, do you wish to say something? Go ahead.
I never had a failure to appear. The only reason why I was failure to appear is because I was incarcerated. So it was a court date that when I was incarcerated, they gave me a court date, but I was incarcerated, so I couldn't show up. I never failure to appear, nothing on nothing. I show up everything, even with these allegations they try to.
Don't talk about that.
No, I'm not gonna talk about it. Even with the allegation they try to accuse me of, I showed up and complied to see what was going on. I don't run. I don't do that. I'm not that type of person, Your Honor. I'm just a person that's just chilling. Even in 2017, that was something that was still ongoing from 2011, a case when I got released. So I haven't had no problems, nothing. I've been and working and getting myself together. I have a child, and I'm not a violent person. You know what I'm saying? Like she said, it was something that happened, and she said out of feelings and whatever. But I'm not that type of guy. I don't even have that type of record of even doing any of this stuff. You feel what I'm saying? We've been together 4 years. We have a child together. You know what I'm saying? I'm not that type of guy.
All right, thank you, sir. At this time, your bond is $5,000 on count 1, $100 on count 2, and $50,000 on count 3. You can have no contact with the victim even while you're in custody. Do you understand what no contact means?
Yeah.
You can't possess.
We have stuff like that we need together. Like if I bond out, that we have together, that even with daycare and stuff like that, like I have.
You can't have any contact with her for any of those reasons.
Even if she wants it.
That's correct. The court is ordering it. So it doesn't matter what she wants, and she's not the one who can be arrested for violating a court order if you have contact with her. Do you understand?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You can't have any contact with a witness in this case.
Can I just say one more thing?
Yes, sir?
I'm not trying to disturb you. I'm not trying to.
No, you can say anything you want.
With the bond on the third count, can you make it more reasonable or affordable for me?
That is actually very reasonable, sir, and I was going to set it much higher, but based on your attorney's arguments, I lowered it. You must maintain a separate residence, but I will allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with her.
You said what was that?
You can't coordinate with her the one-time return to go back and get your belongings. You have to do that with law enforcement.
Can I ask a question?
Just a moment. Are there any other conditions the state would request?
No, Your Honor.
All right, yes, ma'am.
On which charge is he the 50,000 for?
The 50,000 is the sexual battery.
Even though it was consensual?
So I understand that you're saying that here today, but that's not the information that's contained within the probable cause affidavit. The information contained within this is incredibly disturbing. It's very violent. And at this time, I'm not changing that bond amount. All right, good luck. Thank you, ma'am. Good luck. Oh, I'm revoking your bond and you're out on bond case.
I have court for that on the 2nd. I'll be able to go to that.
They'll transport you, or your attorney will waive your appearance.
And we're appointed on the out on bond, Your Honor.
I don't know the answer to that. Do you know?
I just want to make sure he has someone since it's revoked.
Yes.
Okay.
Yes, you are. Thank you for coming, ma'am. Good luck.
Okay.
Please tell me your name. 21 CF 11775. Look at me, ma'am. You're here charged with aggravated battery with a deadly weapon and aggravated battery with a motor vehicle. I'm going to appoint an attorney to represent you. There is probable cause. Ma'am, did you wish to testify?
Yes, ma'am.
Please raise your right hand. Can you just hold him with your left and raise your right really fast? I'm so sorry.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Sorry about that. Could you tell me your name?
Zanisa Chambers.
Oh, wait, one more time?
Zanisa Chambers.
All right, I'm going to let the prosecutor ask you some questions.
Your Honor, I believe arguably there's two different victims, Ms. Chambers and Mr. Mitchum. So arguably, there should probably be 2 counts of the agbat with a deadly weapon and 2 counts of the agbat with a motor vehicle. But given that Mr. Mitchum is not here, I just want to make sure the record was clear.
Yeah, I saw that.
Good morning, ma'am. Can you please state your name for the record?
Zanisa Chambers.
And can you please spell your last name?
Chambers.
Thank you. And what is your relationship to Ms. Grady?
I have no relationship with her.
And do you have a relationship with Mr. Mitchum?
Yes.
Thank you. Are you afraid of Ms. Grady?
Yes.
Would you be willing to call 911 if anything like this ever happened again?
Yes.
Do you want contact with her while this case is pending?
No.
All right, thank you. That's all I have, Your Honor.
All right, does the defense have any questions?
No questions, Your Honor.
Thank you. Ma'am, was there anything else you wanted to say to me this morning?
Yes, ma'am. I wanted to say that I had a 2-year injunction against Miss Grady. And the whole 2 years that I had that injunction, I kept running down to the courthouse, running down to the state attorney's office, trying to let them know that she continued to violate that injunction. While I was out on injunction, her and her friend made false charges and had me arrested. And then when I got pregnant with my son, Miss Grady tried to attack me when I was with my son. And I went to the state attorney office and tried to do an injunction. Miss Grady, she's like my boyfriend grandmother, she's older, and we all take turns to watch her. Miss Grady started hanging out on the street daily, or if she see my car, she'll come over there to start confusion. This day particular, she blocked the street up so we couldn't get out. So, and she's always making threats, and I'm just like afraid for my life and my son's well-being.
All right, thank you, ma'am. I appreciate you coming down here today. Does the state object to pretrial release?
Yes, given the testimony from Ms. Chambers.
Your Honor, I would just point to the fact that she has no criminal convictions, no failures to appear. She's been here for over a year in the Orlando area and currently employed here in the Orlando area.
At Shooter's World.
Yes, Your Honor.
Isn't that a
Yes, Your Honor,
weapons?
that's one of the concerns, given that there was a weapon in this case, and given that she's sitting on 2 F2s.
And
I understand defense counsel's argument that she has no history, but that's because it was expunged.
So, Ms. George, I need some information from you, which you wouldn't have, but at this time, can you have a conversation with your client? I need to know what she does at Shooter's World, because I understand that's her full-time job, but I'm about to order that she can't possess a weapon of any kind, so I need to know if that's part of her job.
Your Honor, Ms. Brady is also, she has a open criminal mischief that was returned to state to do the summons on a criminal mischief, the victim being Ms. Chambers. So the state needs to perfect service, so she does have an open criminal mischief against the same victim, as well as an open no valid in 2020. That case, she failed to appear on 7/16/21. So she is out, failed to appear at a status hearing in front of Judge Dubois in the court D6 her license. So she does have a history that otherwise would not be expunged. So she does have a quite lengthy history, including batteries, violations of probation.
All right, and I'm sorry, Ms. George, I didn't mean to cut you off. Just when you said she's employed and I saw the employer, I just need some information about that, if you're willing to share it with the court.
Yes, Your Honor. I just missed everything that happened just a second ago.
She was talking about some open cases that would not show up as criminal history, but they're open cases, but I can have her repeat it.
Oh, okay. So yes, Your Honor, I did speak about the job. She works in the cafe in the shooter's world. So she does stocking of the cafe and anything that has to do with the cafe. She does not need the access to the guns, but she does use boxing knives to open the boxes. So I just want to make that.
All right, so what I'll make part of my order that she can only use those knives as part of her employment.
Yes, Your Honor.
All right. And I'm sorry, Ms. May, can you repeat the history that you think would be relevant but is not listed because it's open?
Yes, Your Honor. There is a 2020 criminal mischief that was returned to the state to perfect service. The victim being Ms. Chambers, the victim here in court today. It was a criminal mischief. We have filed on it. She'll most likely be served on it before she leaves today. I'll make sure an investigator gets in touch with her. She also has an open, no valid driver's license from 2020 that she failed to appear on, and her license was D6, so that's also open. In addition to that, she does have a 2019 violation of repeat injunction contact.
Is that on the same victim?
That was on, yes, Your Honor, Ms. Chambers. As well as a other prior history, prior battery.
Are you sure she qualifies for PTR?
Yeah, based on her interview, the information she provided, and no criminal history, the charge is qualified.
She has criminal history.
No arrest history. She wasn't arrested on those charges.
Okay. All right, Ms. George, was there anything else?
I would ask, Your Honor, in this case that if you are inclined to not place her on straight pretrial release, that you would place her on pretrial release and require that she post a monetary bond and use pretrial release to lower the monetary bond that you would set in this case, given that she has no criminal history that is, that I can see. I know she has a criminal mischief coming up, but as for of right now, she does not have that. She has not been served on that.
All
Your
right.
Honor, given that the victim's testimony is that there was a violation of an injunction, which was the fact, and given that she does have an open case also against the same victim, state would ask that you just set bond. And given that arguably, I understand the officer did not do it, there are two victims in this case, so there arguably should be 4 charges, not 2. State would ask that you just set bond that is in keeping with them both being F2s, which are rather serious, and given her relationship with the victim seems to be ongoing.
And Your Honor, again, the officer could have charged it that way. He did not. So I just ask that we look at what was charged and we charge her accordingly. Additionally, Ms. Grady's, I believe that her children goes to the aunt's house, which is in the area. So I just ask that you take that into consideration. She states that she's, I guess, in the same, the same road? The same street. Her kids are at the aunt's house.
Yeah, can I say something?
I'm not saying that for this, I'm just giving you context
Right.
as to why she would be over in that area.
Right, that's going to be a problem ongoing. Who said something?
Yeah, I wanted to say something about the area.
Okay.
Okay, before, like, I've been dealing with this family for over 16 years. Been not knowing Kara Grady because I really don't know her, but my child, my boyfriend has a child with her. So ever since those almost 5 years, come October, anything she could do to try to like harass us, she's done that. And ever since her kids got taken from DCF and they was placed on that street, they're no longer in DCF custody. Kara Grady just makes it her business to try to position herself on that street. She lives literally 2 minutes away.
All right, thank you. Here's what I'm going to do. I am going to place you on pretrial release and require that you post a monetary bond. However, I will reduce that amount. At this time, your bond on count 1 will be $15,000. Your bond on count 2 will be $150,000. You can have no contact with either victim or witness in this case. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. What that means is, at your job, you can possess the utility knife for opening boxes, but if you take it out of work and you get caught with it, you'll be arrested. That's a violation of your bond conditions. Do you understand? You can't be within 1,000 feet of the victim's residence or place of employment. Do you understand what that means? So it doesn't matter if you have an aunt in the area or if your kids are somewhere in the area, you cannot be within 1,000 feet of her residence or place of employment for any reason. You understand that? You have to answer out loud.
Yeah.
And also not within 1,000 feet of Mr. Mitchum. His home, place of employment or residence. Right, both victims. Did you say something else?
I wanted to say something. Like what I was saying about the my grandmother's house. We don't live on that street, but we all have to take turns to take care of her because she's older. So that's where the problem resides.
And that's at 4111 Lake Lawn Avenue?
No, it's at 4102 Lakeline Avenue.
In Your Honor, again, the issue is that,
1402.
yep, on that street, the aunt keeps her children throughout the week while she works. So her
And she needs to have her aunt bring the kids somewhere. If that's within 1,000 feet, she can't do it. Because now I'm going to order that you can't return to 1402 Lake Lawn Avenue or be within 1,000 feet of it. So you can't go there. You understand that?
I always go to my aunt's house because DCF said that they can live there.
You got to get closer to the mic. I can't.
she's stating that it's a requirement by DCF. So that's, the order is for DCF that the kids stay with the aunt throughout the week, and that's where she has to go.
The order says that she has to go.
To the aunt's house.
Is the aunt's house within 1,000 feet of 1402? I can't hear you.
She said it's like directly like close by. Like, the grandmother's house is in the corner. Her house is like 3 houses down across the street.
So I'm not sure if 500 feet would suffice, Your Honor, because if it's 3 houses down, as long as she's not anywhere near those houses.
I don't know if they're 500 feet from the street. So if she's driving down the street and has to pass the
Yeah,
house.
she does.
So whose house is first on the street? Your aunt's house or the grandmother's house?
Aunt house first.
All right, so then there's no reason for you to go past your aunt's house.
Ma'am.
Yes, ma'am?
She blocks up the street with her car.
I don't know that I can order her not to block the street. I think what you're gonna have to do is if anything happens, you just have to call the police.
Okay.
I don't think I can tell her that.
And Your Honor, I'll advise my client of that, and that if the police is called, she's the one that runs the risk
Right.
of being brought back here and held at no bond.
Right, this sounds like a very complicated situation, but Ms. Grady, I just want to make sure that you understand that you're the one now who has bond conditions that have been placed on you by a court. If the police get called and it looks like you violated those bond conditions, you can be arrested and held at no bond. Do you understand that?
Yes, I understand. There's also cameras in my auntie's yard, so y'all.
I can't hear you.
I said, I understand what you're saying. There's also cameras that point to the street, so you can see exactly what I'm doing.
That's great. But that's why I want to make sure you understand you're the one that has that at risk. The court doesn't have jurisdiction over the victim. I can't order her to do anything, but I can order you. All right, so I'm going to order that she's not allowed to be within 500 feet of 1402 Lake Lawn Avenue. Good luck, ma'am. Thank you for coming. Good luck, ma'am. 02. All right. Please tell me your name.
Joshua Hammonds.
All right, sir, you have 3 cases here today. A warrant was issued for your arrest in 21 MM 6002 for battery domestic violence. Another judge has already found probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. You can have no contact with Breanne Flowers. You cannot possess a weapon, firearm, or ammunition. You can't be within you can't return to her residence or be within 1,000 feet of her residence or place of employment. In 21 CF 8756, a warrant was issued for your arrest, charging you with burglary of a conveyance with a battery dating violence, petty theft of $100 or more, and tampering with a witness. I'll appoint an attorney to represent you. Again, another judge has already found probable cause here. Ms. May, did you wish to be heard?
Yes, Your Honor, given that count 1 is a punishable by lack of offense, state is asking that you hold him no bond pending an Arthur hearing.
I will do that at this time. On count 1, you'll have no bond.
Ma'am. I'm sorry.
I can't hear you. You have to get close to the microphone.
Ma'am. Okay, look.
Hold on, Mr. Hammond, you understand everything you're saying is being recorded and can be used against you later?
Yes, ma'am. Yes.
Don't talk about the facts of the case.
No, I know. I got to prove that. I was at work. I have the proof for that. That when all this going on, I have proof for that at my job. I have my punching sheets.
Oh, you mean you're saying when the alleged incident occurred?
I was at work. Yes.
Okay. That's a defense to the charge. You're going to have to present that at a later time. So at this time, you'll have no bond on count 1. However, even while in custody, you can't have any contact with the victim. Counts 2 and 3, your bond will be $100. Count 4, your bond will be $2,000. On each of those, you can have no contact with the victim. You can't possess a weapon, firearm, or ammunition. You can't possess or consume any alcoholic beverages. And then in 21 CF 9802, another warrant was issued for your arrest, charging you with robbery, battery domestic violence, and petty theft. Again, another judge has already found probable cause here. Your bond is $5,000 on count 1, $100 on count 2, $500 on count 3. You can have no contact with the victim. You can't possess a weapon, firearm, or ammunition. You can't be within 1,000 feet of the victim's residence or place of employment. And at this time, I'm revoking your bond in 21 CF 8475. Good luck, sir.
Michael Hedden is behavior.
All right, one moment. That's right, okay. That one's right. Okay. 21 CF 11780. Ms. George, I'm going to appoint your office.
I'll waive the appearance, Your Honor.
There is probable cause in this case. I'll set bond at $10,000 on count 1, 100 on 2 and 3 and 4. No victim contact, no weapons, firearms or ammunition, cannot possess or consume alcohol or any controlled substance without a valid prescription. Must maintain a separate residence. I'll allow one-time return with law enforcement. Also, no witness contact. That's all. No contact with any minor child under the age of 18.
Or Martinez Medical.
21 CF 11759. Ms. George, I'll appoint your office.
I'll waive the appearance, Your Honor.
All right, there is probable cause here. His bond is $5,000, no victim contact, no weapons, firearms, or ammunition, maintain a separate residence, and I'll allow one-time return with law enforcement to gather his belongings, no alcohol, no drugs or controlled substance without a valid prescription. Please tell me your name.
Antonella Vilas.
21 MM6113. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Does the state object to pretrial release?
No, Your Honor.
At this time, I'll place you on pretrial release and require that you post a monetary bond of $100. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. Good luck.
I can't see, I'm sorry.
Please tell me your name.
Florence.
I'm sorry, one more time?
Patrick Florence.
Thank you. 21 MM6129. You're here charged with violation of a domestic violence injunction. I'm going to appoint an attorney to represent you in this case. There is probable cause here. Ma'am, did you wish to testify?
Yes.
Please raise your right hand.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
I'm going to let the prosecutor ask you some questions.
Good morning, ma'am. Can you please state your name for the record?
Brittany Dean,
And can you please spell your last name?
DEAN.
And what is your relationship to Mr. Florence?
He's the father of my kids.
And the previous case of tampering with a witness to hinder communication to law enforcement and battery DV from approximately a month ago, are you the victim in that case?
Yes.
Do you want to have contact with Mr. Florence?
No.
All right, thank you. Is there anything else you would like to tell the court?
He'll still call. It'll still happen again. He's been calling me from the jail, even with the no contact order after he was arrested. He's calling my phone. And it's a repetitive, like this has been a cycle for years. I don't even know why they let him out when he busted my head open. Like, why they would even allow him out on bond. Like, it's just a repetitive cycle over and over and over again. I'm done.
I understand, and I'm sorry for all of the trouble, but in the state of Florida, most charges for which people are arrested on, they're entitled to bond. In very few circumstances can the court hold them at no bond. So you asked, you don't know why he keeps getting out. Well, that's the reason. There's only a limited set of circumstances where a judge can hold someone at no bond. One moment. Is there anything else that you want me to know?
I don't want him to get out. I don't feel safe.
All right, thank you, ma'am. All right, Mr. Florence, you understand that everything you say is being recorded and can be used against you later?
Yes, ma'am.
Please raise your right hand.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
I've appointed an attorney to represent you. Would you like to speak with your attorney first?
Just a moment. Thank you, Your Honor.
All right, Mr. Florence, is there something you'd like to say to me?
I'm kind of lost with the situation. I really didn't like fully read the no contact order.
Again, Your Honor, I did advise my client not to talk about the facts of the case, just for the record.
I don't. I've been going to jail for accused of, I really came here to fight for my kids. I didn't ask for this with her. I've been doing the utmost, like going to work, coming home, and I don't get it no more. It's like I've been doing right. I came here for a new start. I just came from St. Pete, from trouble, and just to try to get my kids back. And it's just like, all she had to do was just say, you want this. And it's two sides to a story than just me. I don't feel like, it's like every time, like even if I have an opinion, if I get a little loud, it's the police called for nothing. And it's just like, it's just me now. I never don't pick up the phone to call because I don't go through. I just feel like I could deal with my situation right here with us. I didn't ask for this. You called me. I came to here to just try to get our kids back. If you didn't want me, you could just, I didn't get this. Like you can read my track record, it's nothing. Like it's straight negative. But when my kids was born, they took my kids from us arguing. Just not, I don't get it. No harm came to her or anything. It's just like you tell me that the state attorney and stuff like this, then you invite me in here. You feel me? You invite me home. I didn't have nowhere to go. And then you invite me saying you went to the state attorney. I don't know how this plays out, so I go where I go at. And if we've been okay, if that was okay, you could have just said you didn't want me because I said I was going to call the police and everything.
Mr. Florence, at this point, this isn't about you and the victim. This is about you and the court.
Understand?
A court very clearly ordered you to behave a certain way, and you violated the court order. So that's why you're here today. This is not about you and the victim. This is about you and the state of Florida. You can't violate a court order. Do you understand that?
Yeah, I understand. I just thought when she said she went to the state attorney or anything, I thought the charges was dropped.
So let me explain to you that that's not how this works. The court ordered you to do something, just like the court today is going to order you to do something. I'm struggling right now to come up with any conditions of bond with which you will comply, given the fact that you flagrantly disregarded the last court order, in fact, admitting here today in court that you didn't even read it.
I'm just saying I didn't, when she told me that, I'm just saying I didn't read down, I didn't read it. I'm not going to even lie to you. I didn't know. I was just happy to just try to get out. I didn't think I did anything. And I was just trying to get my family back and stuff like this. But if that.
All right, well, Mr. Florence, I want to make sure that you understand me today.
Yes, ma'am.
Your Honor, before you do conditions, may I?
Yes.
Regarding the victim's testimony here today, Mr. Florence currently has a 2021 non-arrest felony for also violating a no-contact order. That was in July 28th, so approximately a month ago. The victim being Ms. Dean here today. He has a previous 21 misdemeanor violation of PTR condition on a domestic violence case. Victim in that case also being Ms. Dean, the victim here today. He also has a 2021 misdemeanor bad DV case, victim being, again, Ms. Dean here today. In addition to the case that he's being seen on today, as well as his out on bond. State would also like to bring your attention to his failure to appear history. As well, he does have a fairly lengthy history, including out-of-state convictions, as well as a violation of a court order also in Oklahoma. It appears he has a significant history with Ms. Dean. I understand his testimony here today. However, He is able to be held no bond on the violation of domestic injunction. I understand that it's more difficult for the court to make those findings, that there's no appropriate conditions that you could set to ensure his compliance. If you're otherwise not wanting to do that, state would ask for no bond on his out on bond, as he was out on bond and did violate those conditions when he picked up this additional case.
And even with violating the conditions, you're calling me from the jail, which are recorded calls.
We will get them.
In your honor, again, coming into this, the state knew that. The state could have filed a motion of pretrial detention, which was not done. So I would ask that you set a bond on the violation of an injunction.
Respectfully, we do not have to file a pretrial detention motion. If the court finds there's no conditions that will ensure his compliance and the safety of the community and of the victim, you can hold him no bond even without a pretrial detention motion. Given his lengthy violation history, the significant domestic violence history, as well as at least 4 domestic violence cases against Ms. Dean in 2021, state contends that there are no reasonable conditions. However, I understand that is a finding the court has to make, and would just ask for no bond, at least on his out on bond.
So in 21 CF 9553, I will revoke your bond and hold you at no bond. So you have no bond on that case. In 21 MM 6129, Ms. George, I do agree with the state that I already told you, I'm struggling to find any conditions with which your client will comply. He has an incredibly lengthy history. He's demonstrated numerous times, including why he's here today, that he has no intention of complying with court orders. So do you have any ideas of any orders that, any conditions I can place on him that are reasonable with which he'll comply?
Your Honor, again, setting a high bond on the violation, he's going to be held at no bond anyway, so at this point, I don't. If you set a bond on the violation of injunction, since you've already revoked the out on bond, I really don't think it's a moot point at this point. So,
Yeah, he can't bond out on that.
right,
Your Honor.
so he's going to be held here anyway.
They would argue that it's not a moot point. Being revoked on one thing is not synonymous with being revoked on 2. DV attorney could happen just to look at one case, not the other, and agree to a bond. So it's not arguably a moot point if he's only held no bond on one case and not the other.
Your Honor, again, if the state was so concerned about my client getting a bond, they could have filed a pretrial detention motion.
Your point is very well taken, Ms. George. Yes, they could have. And perhaps should have, but that's their decision. However, Mr. Florence, I am looking at your criminal history. I show that you have 5 failures to appear, numerous felony and misdemeanor convictions, several of which are violent, including battery on law enforcement officers. I also show that you have convictions in multiple states.
Only have one, I only have one state, and I had got extradited because I had a charge here. I got extradited for that. I don't even know why I even have a warrant there, because I got extradited from Oklahoma because I had a charge here, and I done did all my time.
It says you have an active warrant in Oklahoma for violating a court order. That's the charge.
But how I violated, I'm in jail. I was in jail. That's the only thing I don't get with that.
I don't know the answer to that. I'm not a judge in Oklahoma, but as I'm considering what reasonable conditions of bond I can place on you, the court is very concerned that, as the state pointed out, the charge out of another state is violating a court order. So it seems to be a pattern of behavior that you don't comply with court orders. So,
Can I say something to you?
again, you can say anything you want. It's being recorded and can be used against you later.
I know I was young and dumb. When my child just got born, we have little jibber dabs and stuff like that, but it's not that serious. Then all them charges was dropped. They don't tell you that these charges was dropped. I wasn't convicted of none of them charges.
I see a lot of charges for which you were not convicted. All of them are violent. Felony battery, aggravated assault, battery domestic violence, tampering with a witness. All of those were dropped.
In your honor.
Those are not your convictions.
And that's understanding, but.
All right, sir, I need you to stop talking. Yes, ma'am?
And all the charges were dropped because I continuously being vulnerable, going down to the courthouse, dropping the charges. And it was because of me dropping the charges over consistently that they terminated my rights, my parental rights for my kids. And I can't get my kids back
I
because of
understand.
these repetitive decisions I'm making. So this time I'm standing my ground on this one.
I understand. All right, here's what I'm going to do. Based on your criminal history and your unwillingness to comply with previous court orders, as well as the fact that you have an out-of-state history, which could mean that you present a flight risk, as well as your prior failures to appear for court, at this time, in 21 MM 6129, I'm not sure there are any conditions of bond I can place on you with which you'll comply. However, based on your attorney's arguments, I will give you a bond. Your bond is $500,000. You can have no contact with the victim. Do you understand what no contact means?
No talk, no nothing, not even look at the person.
Even while you're in custody, you can't call her on the phone. Do you understand that? You can't possess a weapon, firearm, or ammunition. You can't be within 1,000 feet of the victim's residence or place of employment.
Can I ask you this? I have my wallet and things, so just say, my card, I have money that goes to my bank account, right? If she has access to that or anything, how do I go by that? Because I was trying to get my phone, because last time I got out, she took my money off my card and gave it back to me. So that's why I'm thinking that this was a money thing of a situation. Now she have my bank cards and things of that nature. And that's why I don't know if it's a money thing, and
I can't give you any legal advice. I can only tell you that I've ordered you not to have contact with her for any reason at all, via anything, phone, email, computer, friend. You cannot have contact with her for any reason.
I ain't saying a contact with her, but how do I go by that for her not?
I can't give you legal advice. You'll have to talk to your attorney.
Your Honor, I think the issue is that he has items at her house. His belongings are still at the house.
My money,
I'm not letting him back into the house.
I want to go back in the house. I just want to, can I get my cards, my bank card and my phone and things of that nature?
Yes.
That's
No.
all I need.
No. You can't go to her house and you can't have contact with her. So talk to your attorney about filing a motion in front of the trial judge. Good luck. Thank you, ma'am. Good luck.
Thank you.
Okay. That, because when I say that is what I mean. Right. Okay, we're gonna do the Creole. Oh, you do that. This is Judge Gibson. Who do I have on the line?
Hi, this is Isabel DeRocha, court interpreter.
Has the interpreter been sworn?
I have.
All right. I have you over the overhead speaker.
Mm-hmm.
All right. Sir, please tell me your name.
Monsieur qui Jean Ouellet,
Alexis Giovanni.
Alexis Giovanni.
21 CF 11769. You're here charged with aggravated assault with a firearm, domestic violence, and battery, domestic violence.
I'm sorry, Judge. Can you please repeat that?
You're here charged with aggravated assault with a firearm, domestic violence, and battery, domestic violence.
Oui, si un monsieur dans le cas 21 CT 11769 pour attaque grave avec une arme à feu, domestic violence et attaque.
I'm going to appoint an attorney to represent you.
Moi prête un avocat pour représenter vous.
There is probable cause.
Gain assez évidence pour moi accepter bagay yo.
At this time, ma'am, do you wish to testify?
Madame, est-ce que vous voulez témoigner, Kounia?
Please raise your right hand to be sworn.
Levez mes doigts tout pour capable prêter serment.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Go ahead, state.
Good morning, ma'am. Can you please state your name for the record?
Anisha Marshall.
We need the interpreter.
Délégué Alicia Marshall.
So everyone just pause after you ask a question or give an answer so that the interpreter can translate. Go ahead, Ms. May.
Can you please spell your last name?
Marshall.
Il dit non-lit, c'est écrit Marshall.
You mind getting a little bit closer so the interpreter can hear you? Thank you. And what is your relationship to Mr. Alexis?
He's my boyfriend.
Il dit c'est boyfriend ou, ménage-li.
Are you afraid of him?
No.
Li pas peur.
Do you want to have contact with him while this case is pending?
Yes.
Il dit vle gen contact ensemble avec ou pendant que cas en suspens.
Has anything like this ever happened before?
No.
Pas que ça pas jamais arrivé déjà.
That's all I have, Your Honor.
C'est ça seulement li gen.
Any questions from the defense?
No, Your Honor.
Défense pas gen aucune question.
Your Honor, I believe the victim testified to being afraid of him, however, wanting contact, so state at this time would ask for no contact, which could be modified at a later time.
I'm sorry, the interpreter did not get that.
The victim testified to being afraid of the defendant, but wanting contact, so state would ask for no contact while this case is pending, which could be modified at a later time.
I did not say I was afraid. Sorry.
Victime l'a dit que l'était pas monsieur mais que l'était voulait contact m'a demandé pour l'ordre de non contact jusqu'à ce que bagaille fin changer par après et puis victime l'a dit moi pas te dit que moi t'es poli.
What did you say, Miss Marshall?
She said that I said I was afraid of him. I said no to that.
I
T'ai dit que madame là t'ai dit que moi t'es poli ben moi t'ai dit non le lui poser une question ça.
All right, thank you. Miss May, can you
Madame May?
advise what happened with the attempted felony murder with a firearm and great bodily harm with a firearm?
Yes, ma'am.
Hold on, wait till the interpreter.
Bagage ça arrivé tant qu'on attaque physique grave avec une arme à feu et on attaque de violence domestique avec une arme à feu.
That case was no billed due to not able to get victim contact.
Nous pas été capable de contacter victime là, donc nous t'es obligé d'annuler cas.
I believe the numbers that they provided were not in service, and we did have an investigator look into it, and we weren't able to obtain contact from, there were two different witnesses, which I believe were strangers to the defendant.
Okay.
Yo te ban nou un numéro de téléphone que nous qui pas te marché, qui pas en service. Nous te gen un investigateur qui te essayé joindre yo. Et malheureusement, yo pas été capable de joindre yo parce que c'était deux étrangers accusés, donc il pas été capable de plus d'informations.
That case, the arrest was August 5th of 2020 and was no billed in January of 2021.
Kassa, il était arrêté le 5 août 2020 et il était annulé cas en janvier 2021.
At this time, sir, your bond on count 1 is $25,000.
Pour Kounia, monsieur, caution que vous gagnez pour premier chef accusation, c'est $25,000.
Count 2 is $100.
Deuxième chef accusation, c'est $100.
You can have no contact with the victim.
Ou pas capable de gagner aucun contact avec victime là.
Do you understand what no contact means?
I would like to
Est-ce
say
que vous comprenez qui ça, no contact, zéro contact, vle di?
Yeah.
Yes.
You cannot possess a weapon, firearm, or ammunition.
Ou pas capable de gagner une arme à feu, aucune arme ou bien aucune munition.
You must maintain a separate residence, and I will allow a one-time return with law enforcement to gather your belongings.
Ou besoin kembe on l'autre résident, rester dans l'autre caille, m'a pour permettre ou retourner en grande fois avec police là pour ou capable de prendre affaire.
Good luck, sir.
Bonne chance, monsieur.
Thank you, ma'am. Good luck.
No, I would.
Oh, wait, do you have a question?
Yes, I would like to say
You have to get closer to the microphone.
I said I would like to say something.
Yes, go ahead.
I wasn't the one who called the police. My mom did. They repeatedly tried to force me to write a statement. I did not want to press charges, nor did I want him to be in here. I don't know why you're ordering
Ah,
us
moi-même.
not to
Stop.
talk to each
Let her translate.
C'est pas moi-même qui t'ai relé la police, c'était maman moi. En plusieurs fois, il a essayé de forcer moi écrit en déclaration. Moi pas te vle ba yon kon déclaration et moi pas te vle pour monsieur ici en dedans.
Go ahead.
I wish to speak to him, if anything, because, like, he's still my boyfriend. I didn't put him in there. I didn't want him to be in there. If it's up to me, I would drop all the charges.
Et dis moi toujours, moi vle parler avec elle parce que li toujours ménage moi, c'est pas moi qui mettais en prison, moi pas te vle pour te en prison. Si c'était pour moi seulement, moi t'as quitté toute accusation yo tombé.
I understand. Thank you, ma'am. It is not up to you.
Dis-moi comprendre, madame, mais c'est pas vous-même qui avez choisi qui ça pour faire.
The state of Florida is prosecuting him at this time.
C'est l'État Florida qui a prosécuté monsieur pour qu'on y a.
So it's up to them.
Donc c'est eux-mêmes qui ont décidé ça y a fait.
All right. Good luck. Thank you.
Bonne chance, merci.
All right. That's all we have for Creole.
Okay, all right, thank you.
Thank you.
Bye-bye, have a good day.
You too. Give it a minute. Make sure she's disconnected. All right. Please tell me your name.
Tiffany Fuller.
21MM6112. You're here charged with battery domestic violence. I'm going to appoint an attorney to represent you. There is probable cause. Does the state object to pretrial release?
Sorry.
No, Your Honor.
I'm going to place you on pretrial release and require that you post a monetary bond of $100. With special conditions, you can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. I will allow a one-time return with law enforcement to gather your belongings. Good luck. Yes, maintain separate residence.
Is that it? Thank you very much, ladies.
Yes, ma'am. Good luck. Please tell me your name.
Gustavo Izzo.
21MM6131. You're here charged with 2 counts of battery domestic violence. I'm going to appoint an attorney to represent you in this case. There is probable cause. Does the state object to pretrial release?
The state would just ask for bond with PTR, Your Honor, given the nature of the offense, that there were 2 victims and the words that were said.
All right, at this time, I'm going to place you on pretrial release and require that you post a monetary bond of $100 on each count. With special conditions, you can have no contact with either victim or any witness in this case. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings if needed.
I believe they all live in the same location, Your Honor.
Yeah, it says household member. All right. All right, good luck. Please tell me your name.
Jimmy Jennings.
21MM391. You're here charged with violation of a domestic violence injunction. I'm going to appoint an attorney to represent you.
Yes, ma'am.
Currently, I just asked that you set a bond. From what I read in this one, it stated that he did have hostile text messages from the victim in his phone that he did show to the police officer. So I just asked that you take that into consideration, along with the fact that he's been here over a year. 0 failures to appear.
All right, what says the state?
Defense made a comment that there were text messages. However, the injunction doesn't keep the victim from contacting the defendant. It keeps the defendant from contacting the victim. And defense made a note that most of the victim's text messages to the defendant were hostile in nature. Since we don't have those, we don't know what they say. However, since they were hostile in nature, state would contend that the victim potentially did not want to be talking about the case. Given there is an active injunction in 21 DR 6576, he doesn't have a significant DV history, so state has no objection to setting bond. State would just ask for a high bond, given we don't have the victim's input here today.
And I would just point also, Your Honor, to the note that stated for the second. It was, looks like July 20th, 21. It showed that the victim told my client to come over. So I ask that you also take that into consideration, that it appears the victim is in fact playing games and wants my client around. At some point gets upset and then calls the police.
Understanding that, there's still an injunction in place that he has been served with and has arguably read and signed. And it is his job to comply with that injunction, whether or not the victim asks him to come over or not.
Yeah, that's the reason I explain that to all of them when they appear in front of me. Mr. Jennings, I want to make sure that you understand the court doesn't have jurisdiction over the victim at this time. I only have jurisdiction over you. An injunction is a court order. You can't violate the court's order, even if the victim says she wants contact with you. At that point, it's out of your hands and it's out of her hands. But you're the person with everything at stake, because you're the one who can get arrested and held at no bond. So you understand that?
Yes, ma'am.
All right. I also looked at his history. He has a significant arrest history of violent crimes, but not convictions. And I also show a battery out of Georgia, as well as charge, it says out of state, it doesn't tell me where, but obstruction of judiciary, which I'm reading that to be violating a court order. But here's what I'm going to do. Mr. Jennings, I'm going to give you bond in this case. Your bond is $15,000. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am, I read the paper.
All right. Your attorney can give you legal advice about that, but I just want to make sure you understand, again, I don't have jurisdiction over her. I can't stop her from texting you, but if you text her back, you can be in violation of a court order. Do you understand that?
Yes, ma'am.
All right, you can't possess a weapon, firearm, or ammunition. You can't be within 1,000 feet of the victim's residence or place of employment. Even if she invites you, you can't go back. You understand?
Yes, ma'am.
All right, good luck, sir.
All right, thank you.
Javier Maldonado is mental health.
21 MM 6127. Mr. George, I'm going to appoint your office.
I'll leave you if you're.
All right, there's probable cause. I'm going to have him screened for mental health pretrial release. If he qualifies, special conditions, no victim contact, no witness contact, maintain separate residence, one-time return with law enforcement, no weapons, firearms, or ammunition. If, however, he doesn't, his bond is $500 on each count with all the same conditions. Please tell me your name. 21 MM 6120. You're here charged with battery, dating, violence. I'm going to appoint an attorney to represent you. There is probable cause here.
He does qualify for pretrial release, Your Honor. I would ask for pretrial release in this case. He has no criminal history.
What says the state?
State has no objection, Your Honor.
All right, I'm going to place you on pretrial release and require that you post a monetary bond of $100. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes.
That means that even if you were previously planning to fly together, you cannot now. You understand that? You have to answer out loud.
Yes.
Thank you. You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. What that means is, even if you're in New York, you can't live together.
Yes.
All right. Any other conditions the state would request?
No, Your Honor.
Did this happen at the hotel? All right, good luck.
I believe so, Your Honor, Enclave Resort.
Yeah, I just wanted to make sure. Please tell me your name. 21MM562. You're here charged with battery domestic violence. I'm going to appoint an attorney to represent you. There is probable cause. Ma'am, do you wish to testify?
Yes.
Please raise your right hand.
Swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
I'm going to let the prosecutor ask you some questions.
Good morning, ma'am. Can you please state your name for the record?
Natasha Russick,
And can you please spell your last name?
Russek.
Thank you. And what is your relationship to Mr. Penn?
He is my fiance.
Are you afraid of him?
Not at all.
Has anything like this ever happened before?
Never. And we've been together for 6 years.
Do you believe drugs or alcohol were involved in this incident?
No.
And do you want contact with him while this case is pending?
Absolutely.
All right, thank you. That's all I have, Your Honor.
Ms. George?
No questions, Your Honor.
All right, thank you.
Your Honor, I do see he has prior DV history. I'm trying to check to see the victim on that case. It doesn't appear to have happened in Orange County.
It's in Baker County or Duval?
I have it out of Duval, 2013 CF 9288. He was adjudicated guilty for bat DV. It looks like the victim in that case. One second, I'm trying to find the information. The victim in that case, the initials are KP, and it was a felony due to being a bat DV on a pregnant victim.
All right, at this time, your bond is $500. You can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Your Honor, as far as the out-on bond, I would just ask that,
It's not out on bond.
oh,
It's an NTA.
okay, perfect, thank you.
Yeah, I'm not going to revoke. Ma'am, you said you wanted to have contact with him?
Yes, we depend on him. He's our provider. We need him home. He's a great person, a great dad. We've never had these problems. We've been having money problems since coronavirus, and it turned into a disagreement and things escalated. And I just wanted him to leave the house for the night. I didn't think it would get this far.
All right, I'm going to change my order. Based on the testimony here today, I'm going to allow you to have peaceful contact with the victim. But you understand peaceful contact means no hostile contact. Don't raise your voice, no shoving, no hitting, nothing. You understand that? And you understand that you're the person with everything at risk here. Because if you get arrested again, you can be held at no bond for violating court orders. You understand that?
No.
All right, you can't possess a weapon, firearm, or ammunition. All right, good luck. Thank you, ma'am. Good luck.
Thank you.
Please tell me your name. 21MM6119. You're here charged with 2 counts of battery domestic violence. I'm going to appoint an attorney to represent you. There is probable cause. Does the state object to pretrial release?
Your Honor, I believe the victim is also in custody. I believe she's next. Would you like to have them both out?
Yes.
Tranchita.
Ma'am, please tell me your name.
Emily Marie Tranquita.
All right. You're here charged in 21 MM 6118, battery domestic violence, but you're also listed as the victim in 6119. Do you wish to testify as the victim in that case?
No, ma'am.
All right. So does the state object to pretrial release in his case?
Does he want to testify, Your Honor, regarding contact?
Well, I'm going to address his case first.
Then
So
no,
he
Your
wouldn't, I'm not asking him to testify in his own case.
Then no, Your Honor,
Okay.
since we have no victim testimony.
I'm going to place you on pretrial release, Mr. Rodriguez, and require that you post a $100 bond on each count. With special conditions, you can have no contact with any victim or witness. Do you understand what no contact means?
Yes.
You can't possess, I'm sorry?
All my belongings are in her home.
I'll get there. You can't possess a weapon, firearm, or ammunition. I will allow a one-time return with law enforcement to gather your belongings, but you must maintain a separate residence. So you go one time with law enforcement. Any other conditions the state would request?
No, Your Honor.
All right, and then Mr. Rodriguez, you're the victim in 21 MM 6118. Do you wish to testify as the victim in that case?
No.
All right, thank you, sir. Good luck. Does the state object to pretrial release in this case?
No, Your Honor.
There is probable cause here. She has a much more lengthy history, including, was she released from prison in 2018 for robbery with a deadly weapon? No. Robbery with a weapon and carjacking with a firearm.
Yes, Your Honor.
I'm going to place you on pretrial release and require that you post a monetary bond of $500. You can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. I heard him just say that his things are at your house, but you heard me order both of you to do the same thing. So you can't live together, right? So I can't order. Well, it's really weird because I can, because they're both defendants, but talk to your attorney about how to work that out to make sure that you're not living in the same residence. Okay, good luck. Please tell me your name. 21 MM 6130. You're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you.
Your Honor, in this case, the co-defendant we saw earlier, and you did do bond with PTR, so state has no objection for Ms. Valentine.
She doesn't qualify, but thank you.
She could qualify, Your Honor, based on my observance of the previous defendant qualifying.
Why didn't she qualify the first time then?
I don't know, because I would have objected to the other person qualifying, but she could qualify, Your Honor. I don't know why they didn't qualify her. Because she cooperated with the interview, gave us information. We have a contact information, which is her mother. I don't know why.
I thought she doesn't have an alternate residence. That's what it says.
No, I mean, like, we have a contact person. Like, if we can't get in contact with her, we have her mother's telephone number, address, name, everything.
All right, I'll place you on pretrial release and require that you post a monetary bond of $100 with special conditions. You can have no contact with the victim or any witness in this case. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. You can't possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens. Good luck. Please tell me your name. In, it looks like 20 CF 2707, you have a warrant out of
Alachua County.
Alachua County.
Yes, I can explain that.
Hold on. You don't need to explain anything to me. I can't change a warrant out of another county. Ah, there it is, Alachua. Yes, you're correct. It's for violating probation on a grand theft of a motor vehicle and burglary of an unoccupied structure and larceny grand theft. There's no bond authorized. We'll notify them that you're here and I'll appoint an attorney to represent you in the meantime. Good luck.
And Mr. Loganski refused.
20 CT 2269, I'll find his refusal a willing waiver of his appearance today. It's a warrant. Bond is $10,000. I'll appoint the PD.
Yeah, Alexander Lee, a bond.
Bonded?
Bonded.
Okay. Please tell me your name.
Michael Allen Akers.
In 17 CF 7044, you're here for violating probation. At this time, there's no bond. I'll appoint an attorney to represent you. 17 CF 6793 is also a violation of probation. Again, at this time, you'll have no bond, and I'll appoint an attorney to represent you. 17 CF 3218, hold on, I have three.
Oh, I'm so sorry, Your Honor. He's not on probation, he is on parole.
I'm on parole.
Yeah, I don't know why they charged it.
Oh.
No probation.
CRD violation. It's just, I'm just doing 9 months of game time that I earned.
So I think the officer
The
meant.
only reason why I violated is because somebody,
Hold on, I've appointed an attorney, Ms. George, do you want to stand up and speak to him for a minute? The reason she's saying that, sir, is everything you say here is being recorded and can be used against you. So let me give you a minute to talk to the attorney I just appointed before you say anything else. So he is on parole?
Yeah, he's definitely on parole. So he wouldn't even need to be IA'd, but the officers charged it as a violation of probation, which I don't know why, because he's not on probation.
All right. Ms. May, I'm gonna let you figure that out. We're gonna take no action right now. I'm gonna let the state figure out if he needs to be seen on anything, and if he does, we can always bring him back.
You can go. You don't need to be seen.
So was he seen on whatever his other charges are?
That's what, so he'll be seen somewhere else? Is that what you're saying?
Hold on one second.
I haven't even been
No.
charged with anything yet.
Well, that's what I'm not sure about.
I haven't even been charged. The officer said he sent the thing to the state attorney. He said it might not get filed for 33 days or whatever he said.
No, it's about being arrested at this point.
Right. So right now, I'm just waiting on to see what's happening with this.
Hold on, let me ask. What happened with the indecent exposure of sexual organs? Because that's how this started. Has that already been IA'd? I understand that's not a real word. To clarify, has he already been seen by a judge on that?
Well, he just got booked in. So, I mean, on a parole.
Right, but it says, based on the witness's sworn statement and her positively identifying him, I determined there is probable cause to charge him with indecent exposure of sexual organs.
Oh, they didn't.
never filed that as a
They didn't do an affidavit on that.
An arrest affidavit has been forwarded, so they did an affidavit.
I don't have anything within our case management system, Your Honor, I'll check the clerk site, but
They just did the 3.
on-view VOPs.
Okay, I'm gonna let Ms. May figure this out. If we need to bring him back this afternoon or tomorrow, we can do that. But I don't really think I understand what's going on with this.
So is he gonna just sit here?
Till this afternoon he is.
Just till this afternoon?
Yeah.
Okay.
Because I don't know what we're doing. I don't understand what's happening here.
Okay.
It says there was an arrest affidavit. So court's gonna be in recess. I'll see him back here this afternoon.
Thank you.
Yeah, let's just hold these. All right, anything else before we're in recess? Please tell me your name.
Jalen Thomas.
You're here charged with reckless driving. Ms. George, your office represents him.
Yes, Your Honor, we'll enter a plea of not guilty.
The pretrial date will be in Division 84, October 18th at 9 o'clock in courtroom 4B.
All right, good luck, sir. Meadows.
Charles Meadows is restricted movement.
Is what?
Restricted movement.
Thank you. 21 CT 5004, Ms. George, your office represents him.
I'll waive and enter a plea of not guilty, Your Honor.
Pretrial date will be in Division 81, September 15th at 9 o'clock in courtroom 4E.
Penson.
Henson is restricted movement.
21 CT 3287, Ms. George, I'm going to appoint your office.
I'll waive and enter a plea of not guilty, Your Honor.
Pretrial date will be in Division 62, September 27th at 9 o'clock in courtroom 9B.
Whitmore. Please tell me your name.
Whitmore.
21 CT 869, Ms. George, your office represents him.
I'll enter a plea of not guilty, Your Honor. There was no offer given.
Okay.
Pretrial date will be in Division 85, September 20th at 9 o'clock in courtroom 4A.
All right, good luck, sir. Have a nice day.
Yeah.
All right, go ahead. Who do you have next?
My list is Albano, Jeffrey Albano. Do I have present or who?
Hi. No, who do you have next on the list, not present?
Okay, Albano, Jeffrey Albano.
Is next?
He's unrestricted movement, but that's my next one.
All right, 21 MM 5973, Ms. George, your office represents him.
I'll waive and enter a plea of not guilty, Your Honor.
Pretrial date will be in Division 84, October 18th at 9 o'clock in courtroom 4B.
What happened with Lord yet?
Lord Jet, I have Lord Jet. He's on page 2 for me, so we're out of order.
Oh,
List to mine, so that's why this actually giving a name. You want Lord Jet?
yes, please. Yeah, but it's not your voice, it's mine. Please tell me your name.
My name is Jimmy Logrit, Miss.
21 MM 325. You're here charged with trespassing occupied structure. Ms. George, your office represents him.
Yes, we'll enter a plea of not guilty, Your Honor.
Pretrial date will be in Division 84, October 18th at 9 o'clock in courtroom 4B.
Good luck, sir.
Should I have just a moment, Your Honor?
Yes. This is a full docket. It's like 50. Why? Who does that? Who sets them? I want to know because I'm going to tell them, don't do that again. Rivera? Yes. 21 MM 458. Please tell me your name.
He said replace my name.
What's your name?
My name? No. My name is Carmen Rivera.
21 MM 458. You're here charged with retail petty theft. I'm going to appoint an attorney to represent you.
I'll enter a plea of not guilty, Your Honor.
Pretrial date would be in Division 81, September 15th at 9 o'clock in courtroom 4E.
That's your next court date, ma'am.
Okay, is there any way, please, you could release me? I gotta come back in November, they said too. Please, you know, my family.
There's nothing I can do today, but you need to call your attorney and see if they can file a motion for you. Good luck, ma'am.
Okay, thank you.
Yes, ma'am. Courier?
Frederick Courier is restricted movement.
21 MM 5977. Ms. George, your office represents him.
I'll waive and enter a plea of not guilty, Your Honor.
Division 85's pretrial date, September 20th at 9 o'clock in courtroom 4A.
Gaskin?
He is medical.
21 MM 5971. Ms. George?
I'll waive and enter a plea of not guilty, Your Honor.
Division 63, pretrial date, September 23rd at 10:30 in courtroom 12C.
Isaroon?
Iserone is out, Aspire.
21 MM 5970. Ms. George?
I'll waive and enter a plea of not guilty, Your Honor.
Division 61, pretrial date will be October 1st at 9 o'clock in courtroom 6B.
Johnson? Keenan?
Restricted movement.
21 MM 6004. I'll appoint the Public Defender's Office.
I'll waive and enter a plea of not guilty, Your Honor.
Pretrial date will be in Division 81, September 15th at 9 o'clock in courtroom 4E.
Jones? Howard? Please tell me your name.
Howard Jones.
21 MM 6006. Ms. George, your office was previously appointed in the felony case, and then I guess it was remanded.
Yes.
But I'll appoint your office.
Your Honor, the state's offering an adjudication of guilt, credit time served, and no return to the Family Dollar. I did speak to Mr. Jones. We went over all the rights he would be giving up. He understands those rights, and he would like to accept the state's offer here today.
All right, I don't know. I'm going to have to hear more information before I'll determine if I'll accept the offer. Ms. May?
Factual basis, Your Honor?
Yes.
It originally came in, the reason came in as a felony case, it came in, attempt to break structure, loitering and prowling, and resisting without. At approximately 10:33 at the Family Dollar on South Orange Blossom Trail, the defendant attempted to enter the front door of the store, but it was locked because it was after hours. He began to yell and attempt to enter the back locked door unsuccessfully. The victim was able to point him out in the area afterwards, after law enforcement arrived. The defendant then ignored Leo commands to stop when he tried to approach him for questioning. Post Miranda, he said he ran because he had an active warrant. He stated that he thought he knew the person in the store, and that's why he was trying to enter. All events occurred in Orange County, Florida.
All right, Mr. Jones, raise your right hand to be sworn.
Do you swear or affirm that testimony about to give should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am. Yes, Your Honor.
All right, you had an opportunity, you can put your hand down, to speak with an attorney about the rights you'd be giving up if you enter a plea today of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them?
I I heard like I'm gonna be honest. The FTA was for I was supposed to go to a court. Yes. Yes, ma'am. Yes, Your
All right,
Honor.
so you do understand those rights?
Yes, Your Honor.
You don't have any questions for me about those?
No, no, ma'am.
If you have other questions, we can discuss them, but I want to make sure that you understand the rights you're giving up if you enter a plea today.
Yes, ma'am.
Okay.
Okay.
And you had a chance to review that form in front of you. That further
ma'am.
explains those rights.
Yes, ma'am.
All right, you understand it.
Yes, ma'am.
You understand if you're on probation, this plea can violate that.
Yes, ma'am.
If you're not a U.S. citizen, you can be deported.
Yes, ma'am.
All right, at this time, sir, how do you wish to plead to the charges of resisting without violence and loitering or prowling? You can plead guilty, no contest, or not guilty. Yes.
He's been revoked on other things. So he's,
I didn't sign for probation. I think they're trying to get me.
That's what you're not listening to me. Or are you trying to work out a deal?
Go very far.
Okay. Keep
No
going.
contest.
No contest.
All right, you do understand that you can also plead not guilty today and continue this to be heard at a later date, right? You don't have to plead guilty or no contest. I want to make sure you understand that.
Yeah, the issue is he's a little confused as to whether he's on probation or not. So he wants to plead not guilty, Your Honor.
Okay, I understand.
Just to be safe.
Right, and I don't have that information for you, so I can't tell you if you are, so I would listen to my attorney if I were you.
It does say that in our system.
That he is.
That he is on probation?
Perfect. Thank you.
Okay. All right, so enter plea of not guilty.
Pretrial day will be in Division 84, October 18th at 9 o'clock in courtroom 4B.
Good luck, sir. That's your next court date.
All right. When? Huh?
October 18th at 9 a.m. in 4B.
All right.
All right, good luck, sir. Good job, Ms. George. Leon? Please tell me your name.
Christopher Leon.
21 MM 5972. I'm going to appoint the public defender's office in this case.
And we're going to enter a plea of not guilty, Your Honor.
Pretrial day will be in Division 82, September 27th at 10:30 in courtroom 10B.
Good luck, sir.
I have a quick question. This is for the trespass of a conveyance?
Yes, it is.
I spoke with my attorney yesterday, and she told me that I was going to have 61 days time served on the case. She said that I was going to get pleaded out today.
Who is your attorney?
This is
Is she a public defender or is she a private attorney?
public defender. It's Nancy Marcelli.
So I don't show that. I show 42 days, but for some reason, the state doesn't have an offer for you at this time.
It's a true victim case, Your Honor.
So I think it's because statutorily, the victim has the right to be here for all significant court dates. So at this time, the state's not offering you anything, and I'm not accepting a plea. So you can't plead today.
All right. Thank you.
Good luck. Paramore? 19MM 6819. Please tell me your name.
Paramore.
All right, she's here charged with battery. Ms. George, I'm going to appoint your office.
And I'll waive and enter plea of not guilty, Your Honor. I mean, not waive, sorry, enter plea of not guilty.
Pretrial date will be in Division 81, September 15th at 9 o'clock in courtroom 4E.
Good luck, ma'am. Is it De Silva? Valentin De Silva? 21MM 5573. Ms. George, your office represents him.
I'll waive and enter a plea of not guilty, Your Honor.
Pretrial date will be in Division 83, September 13th at 8:30 in courtroom 6C.
Vasquez Colon.
Medical?
Where? Oh, all right. 21MM 5974. He has an attorney.
Oh,
Who is it? Do you know? Oh, it's conflict.
Yeah, RCC got appointed, Your Honor. Yes.
I think we need to reset him for tomorrow and notify Regional Conflict Council that he's set for arraignment. All right, so let's reset him for tomorrow. All right, I'm ready. Please tell me your name.
Benjamin Cruz Vargas.
21MM 6132. You're here charged with violation of a repeat violence injunction. There is probable cause. I'll appoint an attorney to represent you in this case. At this time, your bond will be $5,000. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am. Can I tell you, Your Honor, I have problems speaking English sometimes because I get nervous with these guys. He's lying.
Okay, hold on. Let me explain. We're just here today for a probable cause determination. Let me ask you a question. Do you need me to get an interpreter? You said sometimes you have trouble speaking English. Can you understand me?
Yeah, I understand you, but the old man that I'm taking care of the house, he's in coma in the hospital, and I got my dogs and all my tools by himself because they arrested me yesterday, and I need to get home because my dog's gonna die, and I don't want nobody steal my tools. Because
All right.
I started.
All right, sir, just a moment, Mr. Cruz.
Yes, ma'am.
We have a couple things we need to deal with. So in this case, you can have no contact with the victim. You can't possess a weapon, firearm, or ammunition. You can't drink or possess any alcoholic beverages. Where do you live? Is it close to 7709 Liverpool Boulevard?
I live on 7708 Liverpool Boulevard.
Oh, you live next door.
They're neighbors, Your Honor.
You can return to your home, but you can't go to their home for any reason. Do you understand?
I never, he used to be my friend. I call his yard, but he got Parkinson and brain cancer. So even his wife yesterday, she came out and told him, don't mess with me. I didn't tell him nothing yesterday.
okay, don't talk about stuff.
All right.
If you, okay.
So is the out on bond 21MM 4623, is that with the same victim?
Yes, Your Honor, same victim, and that arrest was July 4th.
Your Honor,
And then
Your Honor, I believe this is as my client stated, the neighbor may have some health issues, but if you read the arrest affidavit, it states that the neighbor was trying to give him some food. Like, it's not a normal violation of an injunction. I just actually think you're right into consideration. I know the dynamic seems to be weird to me, Your Honor. And the fact that he did come over to bring him some food, I just ask that you take all of that into consideration and not revoke the out on bond. If he does in fact have Parkinson's, as stated, and brain cancer, he may have memory loss and issues. and things to that effect, Your Honor.
Your Honor, the state's issue is the threats made in the instant case, as well as there are threats made in the previous case as well. And given the proximity, the state would ask that you revoke so this can be addressed in a full hearing with the victim present.
Yeah, so the court's concern is also they live next door, and according to the probable cause affidavit, it says some witnesses heard them yelling back and forth and then took their families inside because they didn't want to be part of whatever the issue is. So I agree, Ms. George, reading it, it sounds like there's some different dynamics in there, but because they live next door and he's out on bond for contempt of court.
Can I have a moment here?
Yes.
Your Honor, I would just ask that, given the situation, the facts of the case, and the testimony here by my client and reading the arrest affidavit, I would just ask that you not revoke his out on bond. I just spoke with my client. He is willing to relocate. He states that he can go somewhere else to live. So if you just to give him a one-time return to get his belongings with law enforcement, he won't go back to that house. They won't be neighbors, and it'll eliminate the issue.
Okay, what says the state? Thank you.
Our state still has potential safety concerns regarding the victim. He was out on bond for this. There is an active injunction. He made threats to kill in this instant case. In that other case, on July 4th, law enforcement arrived. The victim reported he stepped out of his house, heard the defendant yell, "I'm going to kill you and your family." The defendant was then standing by his mailbox, and the victim drove his car by. The defendant yelled again, "I'm going to kill you and your family." Due to there being an active injunction and the proximity and the continued threats of killing, state is concerned for the victim's safety. I understand the defendant's testimony here today, but without the victim's testimony, I'm worried for the victim's safety and his wishes. I understand that he potentially has
Give me a second.
medical issues. However, I believe this can be addressed better in a full hearing when the victim can be heard. That case was filed on, and we did have victim contact, I believe. So it seems like the victim is going forward. That case has been filed.
Were there any independent eyewitnesses in that case?
Not that I see, Your Honor, within the affidavit.
And Your Honor.
What about, hold on one second, let me ask another question. Battery on a person 65 years or older, that shows as a conviction. Can the state tell me when that was? In the child abuse? And go ahead, Ms. George, did you have a question or something to tell me?
Yes, Your Honor. I was just arguing that if we remove him from being neighbors with him, that I believe that that condition would eliminate any further issues. And the purpose of him being out on bond is to make sure he shows up for court. He's going to show up for court. He doesn't have failures to appear that I know of, Your Honor. And if you look at the arrest affidavit, it kind of hints to what my client is stating. There may be some mental health issues, because he did come over. For there to be such back and forth between the two. It was weird that he was bringing him food. It just doesn't make sense. I don't know. I don't know. Something's wrong.
It's the same things that the defense is bringing up that I think could be addressed in another hearing. In 2008, we originally filed a lewd and lascivious conduct, exposure of sexual organs, child abuse, and a VOP. You pled no contest to the exposure of sexual organs, child abuse, and the VOP. And that was 2008. In 2010 was the bat on person 65 or older.
Who's the victim? Is it the same victim?
Mr. Aviles, no, someone else, Your Honor.
All right.
But since this case, he currently has the 529 open violation of injunction. He has the 4623 contempt of court violating the injunction, and he has a 21 misdemeanor non-arrest, also contempt of court violating the injunction. That 2020 misdemeanor non-arrest happened July 28th. So currently, we have 3 that are open, July 1st, July 28th, and then this current one.
Ms. George, I found most of your arguments very compelling, but I am still concerned about the fact that there are 3 open violation of injunction.
Yeah, I didn't know that.
Right. I didn't know that either.
I'm sorry, we received a phone call from the victim on 8/16 wanting to prosecute. So if you revoke today, there could be a full hearing to get him bond where the victim could testify to be able to set a reasonable bond on his out on bond.
All right, here's what I'm going to do. On the 21 MM 6132. What did I say the bond was? I'll leave that bond. However, I am going to revoke your bond in 21 MM 4623. So you need to have your attorney file a motion right away to set a hearing for you. All right, good luck, sir. Good.
And again?
I'm sorry? Porter.
Order was refusal.
21 MM 6122. I'll find his refusal a willing waiver of his appearance today. There is probable cause. Ms. George, I'll appoint your office. I'll stay the bond. It'll be 100 on count 1, 500 on count 2, no return, no witness contact. Please tell me your name.
Melody Ann Smith.
21 MM 6125. You're here charged with battery. There is probable cause, and I'll appoint an attorney to represent you. Your bond is $500. You can have no contact with the victim. You can't possess a weapon, firearm, or ammunition. You can't return to 3400 North Forsyth Road. Yes, ma'am.
That's where I keep my storage, ma'am, and I don't have anything to do with that guy. He's the one who started the garbage with me. I didn't do anything to him but to try to defend myself walking out of a doorway. It's the other way around.
All right, at this time, I'm still going to order that you can't return there for now. Your attorney can file a motion in front of the trial judge for them to change that.
My things, I can't go get my toiletries, I can't get my clothes and move out of there. It's a storage unit, ma'am.
Yes, I understand it's a storage unit.
So I can't move out?
Is that what you're trying to do?
Yes, I want to move out.
All right, I will allow you a one-time return with law enforcement to gather your belongings. Did I say no weapons?
Law enforcement to gather my belongings. Do you realize I have a whole half a truck full? I need a lot more than law enforcement. I don't want law enforcement involved with me.
All right, they're not going to carry your belongings, ma'am. They are accompanying you there so that you don't have contact with anyone that you shouldn't.
That guy assaulted me, and he's getting charged too.
All right.
He just gets to walk away for all the stuff he did to me and said to me? Is that right?
I thought you just said he's being charged.
You're allowing him to victimize a disabled person.
No, ma'am, I'm not allowing him to do anything. This court doesn't have jurisdiction over a victim of a crime. The court only has jurisdiction over you at this point.
You're not even letting me tell the story.
Ma'am, you can say anything you want, but everything you say here is being recorded and can be used against you. Do you understand that?
I want to tell the story.
Did you hear what I said?
No, I'm going to tell the story.
Ma'am, did you hear what I said?
Go ahead.
Okay. Everything you say is being recorded and can be used against you later. Do you understand that?
I understand my rights.
Raise your right hand.
Do you swear or affirm that the testimony about to give should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. Your attorneys advise you not to talk, but at this time, you want to say something to the court?
Yes, I do.
All right, go ahead.
There's a timer on the wall. There's a timer on the wall. Excuse me. My name is... There's a timer on the wall that sets the time of how long you can stay in the storage, and then you have to redo the time again. So he's very vindictive. He wants all the lights out in there. And I'm like, that's freaky. I'm alone in the room with a man with all the lights out. I got kind of scared of him. So he scared me, and I'm sorry, but I did not assault him. I did not batter him. If there's any battery done, I would like to see the evidence. I would like to see the assault done to him, and I need him to prove that in court, because I did not batter him, nor did I assault him, nor did I threaten him. I am a black belt, and I will bring Naga into this.
All right, thank you, ma'am.
There's no way I would lower myself down to that integrity, ma'am. I have more integrity in that,
All right, thank you.
and I have more respect for myself. I wish to walk out of here scot-free. I don't want to hurt nobody.
All right, I appreciate that, ma'am. I'm going to leave your bond conditions as they are.
Bond, I can't afford to pay attention. You want to put me on bond?
Yes, ma'am, your bond is $500 with all of those same conditions that I previously ordered.
I can't afford $500, ma'am.
Your attorney can file a motion to reduce that bond in front of the trial judge, but I'm not going to reduce it today. Look at the phone number on that green piece of paper. Call that number so you can speak to your attorney as soon as possible.
What attorney?
I appointed an attorney to represent you. Good luck.
Why can't you just say, Melanie, I'll just give you a break, because I didn't do anything wrong but try to defend myself from a nut.
I understand what you're saying, ma'am, but I have to review all the evidence that I have in the probable cause affidavit. At this time, there is probable cause.
Okay, so I'm allowed there to go move my things out in peace.
Yes, ma'am, with law enforcement. Make sure you call law enforcement and coordinate that with them.
No problem. Am I going out of here today?
If you post your bond, you can be released. Yes, ma'am.
Post my bond, what's that mean? Come on.
Please tell me your name.
Eric Woods.
21MM6115. You're here charged with trespass on property after warning. There is probable cause. Is there an offer?
Yes, Your Honor. The offer conveyed was an adjudication of guilt, credit time served, and no return to the Kingston Reef Hotel.
I did speak to Mr. Woods. We went over all the rights he would be giving up, and he would like to accept the state's offer here today, Your Honor.
Please raise your right hand.
Do you swear or affirm that the testimony about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you had an opportunity to discuss with an attorney today the rights that you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them?
Oh, ma'am.
Were you able to review that form in front of you? It further explains those rights.
Yes.
All right. You understand if you're on probation anywhere, this plea can violate it.
Yes.
If you're not a U.S. citizen, you can be deported.
Yes.
All right, sir, at this time, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days you've spent in jail. I'm ordering that you not return to the Kingston Reef Hotel. You know where that is?
Yes, ma'am.
You can't go back there.
Yes.
And I have to order that you pay court costs. I'll give you a year to pay it.
Okay.
Good luck, sir.
Yes.
Please tell me your name.
Tony Ann Fecky.
A warrant was issued for your arrest in 21 MM 5958, charging you with battery. Another judge has already found probable cause. Your bond is $1,000. You can have no contact with Maria Carr. You cannot return to the Christian Service Center. You can't possess a weapon, firearm, or ammunition.
Yes, ma'am.
Thank you. At this time, I'm revoking your ROR in 21 CF 4746. All right, good luck, ma'am.
All right, so my understanding is I no longer have release, I have to hold for the other case. but
Right.
I have my bond for the new case.
Right, you have a bond in the new case, but because you were out on bond when you were arrested for committing a new crime, I revoked your other ROR. So at this time, you can't bond out. But your attorney can file a motion in front of the trial judge to get you a bond. So call your attorney right away.
Yes, ma'am, thank you.
Yes, ma'am, good luck.
Nora Hurst. That's your next one first. His mental health.
21 MM 4490. Ms. Georgia, I'm going to appoint your office.
I'll waive the appearance, Your Honor.
It's a KPS, the bond is 150.
Witherington is a bond.
Bonded?
Yes.
Please tell me your name. What's your name?
Carmelo Ayala Perez.
21 MO 996. You're here charged with open container of an alcoholic beverage. Was there an offer?
Yes, Your Honor, I've been authorized on the city's behalf to offer a withhold credit time served.
There is probable cause here.
He's on probation. I would
Ah.
definitely not take it off.
All right, then I will stay your bond at $250. You can't possess or consume any alcohol, you understand? Can you understand me, sir?
It's fine.
He needs.
You need Spanish?
It's 1209.
Oh, we're not gonna get an interpreter now.
Okay, but can you speak slow, obviously? I can understand a little bit.
Yes, sir. Your bond is $250. Do you understand?
Yes.
You cannot possess or consume alcohol. Do you understand? Don't drink. You understand that?
Yes, ma'am.
That's all. So do you have any questions for me?
Need to pay $250,
Right.
not 10%.
Oh, that's between you and a bondsman. It may be 10%. I can't decide that. But if you call the phone number, you can talk to your attorney. Okay, good luck. Please tell me your name.
Cortez Campbell.
I'm sorry, one more time?
Cortez Campbell.
Thank you. 21 MO 997, you're here charged with disorderly conduct. There is probable cause.
In Your Honor, I believe the offers of withhold credit time served. I did speak to Mr. Campbell. We went over all the rights he would be given up. He understands those rights, and would like to resolve the case today.
So I don't know if I'll accept that, and he's out on bond for a battery on a law enforcement officer. So I'm going to have to get more information from the state to determine if I'll revoke that bond.
Your Honor, state was going to ask for it to be revoked even if he pled due to being out for a battery and picking up a new battery.
He doesn't have a battery.
It's not charged as a battery. It's charged as disorderly conduct. However, that is my concern after reading the facts. It's a violent offense, and he's out on bond for a violent offense.
Charges as disorderly under fighting and brawling is the allegations of the disorderly.
Can you tell me the factual basis for the battery on a law enforcement officer?
On or about October 19th of 2020, a law enforcement responded to the scene due to the defendant not leaving the premises. The defendant was asked to leave the bar and was removed. He then attempted to re-enter the bar and start a fight with the bar security. Law enforcement stepped in between security and the defendant. The defendant started to yell at the officer and move around him. The defendant was told to leave and he refused. The defendant then reached out and touched Leo in the chest. The defendant was told not to touch Leo. The defendant then began yelling at the officer and put his finger in the officer's face, screaming expletives, and that he would pee on him. All events occurred in Orange County, Florida.
All right, so, Mr. Campbell,
Just a second.
okay,
And in that case, he is represented by private counsel.
by who?
Private counsel, Corey Cohen's office.
Thank you.
He was also potentially going to sign a PTD contract in that case in the next 15, 16 days. However, that might be rescinded due to this new case if he pleads.
I saw that, the PTD pending. Yes, Ms. George?
He wanted to tell you something, Your Honor. Go ahead.
Before you do, I want to make sure that you understand what's happening, Mr. Campbell. So at this time, based on the fact that this new law violation is substantially similar to the last one, I'm not accepting the negotiated plea. If you want to enter a plea, you have to plead open to the court. I don't know what I'm going to do. Once I hear from you, I'll make a determination about what the sentence will be and whether I'll revoke your bond in the battery on a law enforcement officer case. But I want to make sure you understand that because this charge, is this a second degree?
The Batleo?
No, the disorderly conduct.
Yes, Your Honor.
So it's punishable by up to 60 days in jail. I'm not telling you I will sentence you to that. I'm telling you that's the maximum. So I want to make sure that you understand that. The state offered you 2 days. I'm not accepting that. I don't know what I will sentence you to until after I hear from you. But I want to be sure you understand that your exposure is 60 days on this charge. Do you understand that?
Yes, ma'am.
All right, do you want to have a moment and talk to your attorney before you?
Yes.
Okay, go ahead.
Your Honor, we're gonna, because he was supposed to sign up for pretrial diversion and him pleading may potentially kick him out and he has a private attorney, I don't want to mess that up. So I would just ask that you set a bond in that case. However, in this case, however, I would ask that you not revoke his out on bond and set him at no bond. And he's gonna explain briefly about the new charge to give you some context, but I just wanted to make the argument that I also would ask that you take into consideration when considering to revoke his out on bond, the fact that he is currently employed full-time. He's been there for 2 years. He's been in the Orlando area for over a year, and that he has no convictions here in Florida. And it looks like the conviction he does have is a theft out of state. That's the only one that I see in 2014, Your Honor. So I just ask that you consider all of that, and if you are inclined to revoke, you at least revoke and potentially double the bond, and make a condition of his bond that he's not allowed to go into any clubs, Your Honor.
All right, thank you. Did I already set bond in the new case?
I don't know.
Okay, so before you say anything, your bond in this case is going to be $500. Let me tell you about your bond conditions, and then we'll talk about the other, okay?
Yes, ma'am.
You can't go back to Tier Nightclub. You know where that is?
Yes, ma'am.
Okay, you can't possess or consume alcoholic beverages, and you can't have contact with any victim or witness in this case. All right, so I am setting bond in that case, and I'm staying it where it was. Is there something you want to say to me?
About this case? Oh, yeah, like,
Either one, what you want to say, remembering that it's all on record and can be used against you later.
Yeah, he's just gonna explain why the officer didn't charge him for.
yeah, the officer said that he didn't charge me for battery because he didn't see me hit anybody. He maced me. So he said because he had laid hands on me that he had to charge me with something. That's what.
Oh, I see.
I never hit nobody. I was just there.
Okay. I see. Thank you.
Your Honor, the affidavit reads differently.
It does. I understand. I think anytime there's two sides of a story, right, the truth could be somewhere in the middle, but I also think that during an affray, who does what could sometimes be difficult to ascertain. So I'll stay that bond as it is.
Your Honor, State's just asking that you revoke and double his out on bond. I believe it was $5,000.
It is, and I'm going to do that. I was originally going to revoke your bond and hold you at no bond, but based on the argument of Ms. George, who is not representing you in that case, but in the new case, I will double that bond. So I will allow you to be released, but you cannot possess or consume any alcoholic beverages. You can't go to any nightclub or any bar. So no establishment whose primary purpose is to serve alcohol.
Yes, ma'am.
You understand?
Yes, ma'am.
So you can go to Outback Steakhouse because it's really a restaurant, but you can't go to Tier Nightclub because it's a bar.
Basically like downtown, basically. Or just any.
Right.
I got it.
Right.
All right.
All right, good luck, sir. 10. Yeah, it was 5, I'm doubling it. Yeah. Sir, please tell me your name.
Robert Hill.
Good afternoon, sir. 21MO999. You're here charged with disorderly conduct. Was there an offer?
Yes, Your Honor, I've been authorized on the city's behalf to offer a withhold credit time served.
Ms. George?
I did speak to Mr. Hill. We went over all the rights he would be given up. He understands those rights, and he would like to accept the state's offer here today.
All right, Mr. Hill, raise your right hand, please.
Do you swear affirm that the testimony about to give should be the truth, the whole truth, and nothing but the truth?
I do, yes.
All right, Mr. Hill, I feel like you look familiar. Do I look familiar to you?
No, ma'am.
Oh, I didn't see you back in July?
Oh, disorderly.
Yes, ma'am, I was.
That's what, I thought you were here before.
Yes, but it was a different judge, yes.
Oh, it was a different judge. Oh,
Yes, ma'am.
I thought I saw you. All right, sir.
Yes, ma'am.
So you had an opportunity to discuss with an attorney the rights you'll be giving up if you enter this plea today. Do you understand those rights?
Yes, ma'am.
All right, you see the plea form in front of you. It further explains them. Did you have an opportunity to review that?
Yes, ma'am, but I want to resolve everything today, that's fine.
I understand. I just have to make sure you understand all these rights before I can do that.
Yes, ma'am.
Do you have any questions for me about the rights you're giving up?
No, ma'am, no, ma'am.
You understand if you're on probation, this plea could violate that.
Yes, ma'am.
You understand if you're not a U.S. citizen, you could be deported.
Yes, ma'am.
At this time, how do you wish to plead to disorderly conduct?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days you've been in custody. I have to order that you pay court costs. However, I'm going to reduce that to a lien. Good luck, sir.
Thank you, ma'am.
Cruz Soto, the bond.
I'm sorry, who?
Cruz Soto.
Okay. Thank you. Please tell me your name. 21 CT 5995. You're here charged with DUI. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can't possess or consume any alcoholic beverages. You'll be subject to random alcohol screens. You also can't possess or consume any controlled substance without a valid prescription, and you'll be subject to random drug screens as well. You can't drive without a valid Florida license. At this time, I'm revoking your bond in 21 MM 332. Good luck, sir.
Does that mean?
You okay? Please tell me your name. 20 CT 628, a capias was issued for your arrest for failing to appear for arraignment on a charge of no valid driver's license. The bond is $150.
Your Honor, there was an offer conveyed in this case of a withhold credit time served.
Were you able to find anything for a driver's license? Your Honor, sorry, because at one point she thought she had her driver's license. She wants to resolve the case today with the withhold of adjudication credit time served. We did go over all the rights she would be given up. She understands those rights, and she would like to accept the state's offer here today.
All right, Ms. May, why should the court withhold adjudication in this case?
I understand she has out-of-state history, Your Honor, but it was approximately a year and a half old, or 10 and a half years, 10 years old. I don't have any notes on any of that. 10 years.
Okay. All right, Ms. Richardson, raise your right hand.
Do you swear affirm that the testimony about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down. You had an opportunity to discuss with an attorney the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Kind of. Yeah.
All right,
Kind of.
do you have any questions for me about them?
I just don't, I didn't understand really the difference between the two other than,
Guilty and no contest?
yeah.
All right, so if you enter a plea of not guilty, you're denying the truth of the allegations and will set your case to be heard at a later time. If you enter a plea of guilty, you're admitting the truth of the allegations against you. If you enter a plea of no contest, what you're saying is, you're not admitting it, but you think it's in your best interest to enter a plea, and I'll treat that the same as a guilty plea and sentence you today. So do you understand that?
I think so.
All right. How about all the other rights? Like you're giving up your right to a jury trial when one is required, your right to remain silent, your right to testify on your own behalf. Do you understand all those rights? Do you have any questions for me about those? All right. Do you understand that if you're on probation anywhere, this plea could violate that? If you're not a U.S. citizen, you can be deported. You have to answer out loud. You have to speak out loud.
Yes, I'm sorry.
All right. At this time, understanding all of that, which plea do you want to enter to the charge of no valid driver's license?
No contest?
You understand if you enter that plea today, I'm going to sentence you today? Yes?
Yes, ma'am.
All right, I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the time you've been in custody. 2 days. I have to order that you pay court costs, and I'll give you a year to pay that. Do you understand?
Yes, ma'am.
Do you have any questions for me?
No.
All right, good luck. You have 30 days to appeal in writing.
Thank you.
Yes, ma'am. Please tell me your name. What's your name? A capias was issued for your arrest at 20 CF 6197 for failing to appear on charges of trafficking in 10 grams or more of phenethylamines, carrying a concealed firearm, thank you, resisting without violence, and possession of drug paraphernalia. On count 1, there's no bond. Counts 2, 3, and 4, your bond is $2,000 each. I'll appoint an attorney to represent you. Good luck. I'm sorry? Oh, he has an attorney? All right, then I'm not going to appoint an attorney, but if, call your attorney that you have, and if something happens, we can always revisit that. Yes, sir?
You talking about a PD?
No, it shows that you have Leslie Sweet.
She kind of dropped me. Like, I was trying to talk to her and stuff like that. I don't know why, but she kind of said she wasn't dealing with me no more.
But it shows that she, I think in the clerk's system, it still shows that she represents you.
Really? Because I checked it out. It says she dropped me.
She said she's no longer representing you.
I talked to her on the phone. She pretty much told me that to myself. Like, she didn't, I don't know why, but she didn't know what I was going through. I was in the hospital with my brother. Like, my brother was fighting for his life. Got a hole in his throat. It's pretty much my brother, like, went from 30 years old to 3 years old.
All right, hold on one second.
Diapers and everything. That's the only reason why I missed the court.
Your Honor, on 5/25/21, the court minutes say Ms. Sweet made an ordinance motion to withdraw. On
Okay, it was
5/25.
Ortenis?
Yes, Your Honor.
All right, then I will appoint the public defender's office to represent you. Good luck, sir. I'm sorry to hear about your brother. I hope he does well.
Your Honor, during the ordinance motion, I'm reading the court minutes. The Judge Wilson took no action and told her to file a motion withdrawal. You still.
Oh, and there is no motion?
It was an ordinance motion and the judge took no action and told her to file one.
When was that?
May 25th.
Oh, my
There's been no
goodness.
motion filed since.
So technically, she still represents him.
Technically, yes, Your Honor, but it seems like he is also technically without counsel.
Your Honor, I would just ask, at least temporarily, being that he's being held at no bond, if you appoint us, then maybe we can go ahead and get them, her to file the motion and have us appointed.
All right, I'm going to leave them appointed in your case, but see if you can call Miss Sweet because it's very confusing.
I talked to her already. She didn't know what I told her, what I was going through, and my brother was fighting for his life.
Tell her the court said she was ordered to file a motion. She needs to get that done. So it's not you telling her, it's the court.
Okay.
Good luck, sir.
Thank you very much, ma'am.
Yes, sir. Please tell me your name.
Emilio Castro Frias.
In something without a case number. You're charged with driving while license suspended. This doesn't have a case number. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can't drive without a valid Florida license. 21 CF 11777, you're charged with grand theft of a motor vehicle. Again, I'm going to appoint an attorney to represent you. There's probable cause here as well. Your bond is $1,000. You can't have contact with any victim, witness, or co-defendant in the case. At this time, I'm revoking your ROR in 21 CF 6632. All right, good luck. Please tell me your name.
Moniz, Rafael.
21 CF 8597, a capias was issued for your arrest for failing to appear on charges of possession of cocaine, drug paraphernalia, and resisting without violence. There's no bond at this time, and I'll appoint an attorney to represent you.
I never received any mail or anything as far as me being notified to being represented in court. Even my lawyer didn't tell me to come.
That may be, but I can't change another judge's capias, so you're going to have to raise those defenses in front of the trial judge who signed the capias. As to his out on bond case, I'm going to take no action. Good luck, sir. Please tell me your name.
Sandra Cabello.
21 CF 11782, you're here charged with possession of cocaine. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. You can't possess or consume any controlled substance or have contact with any known drug dealers. In 21 MM 5996, I'm going to revoke your bond.
Huh?
I'm going to revoke that bond.
What does that mean?
That means that at this time, you'll be held at no bond on that charge. You need to call your attorney and have them set a motion in front of the trial judge. Good luck, ma'am. Please tell me your name.
Alexander Fontanez.
21 CF 11756. You're here charged with trafficking in fentanyl, 4 grams or more, possession of a firearm and commission of a felony, possession of cannabis with intent to sell or deliver with a weapon, possession of tetrahydrocannabinols, open display of a firearm, and possession of drug paraphernalia. I'm going to appoint an attorney to represent you in this case. There is probable cause. Does the state wish to be heard on bond?
Your Honor, count 1 is just an F1, so he is entitled to bonds. The state just requests that you set a reasonable bond. I see that he qualifies for PTR. However, state would object, given that he does have, it looks like, at least 2 prior VOPs showing an inability to comply with court orders, which PTR is a court order. So state would just ask for a reasonable bond. And if you're otherwise inclined to put him on PTR, state would ask for bond with PTR.
I don't understand how armed trafficking qualifies for pretrial release.
Yes, Your Honor. Agreed.
Ms. George, did you wish to be heard?
Your Honor, I just asked that you take into consideration the fact that he has community ties. He's been here for over a year. It's showing 0 failures to appear. So I ask that you take all of that into consideration, and he's currently employed when setting up bond.
All right, at this time, your bond is $100,000 on count 1, $5,000 on count 2, $7,500 on count 3. And then I'll treat 4, 5, and 6 as subsidiaries. So it'll be $150 on count 4, $100 on count 5 and 6. You can have no contact with any known drug dealers. You can't possess a weapon, firearm, or ammunition. You can't possess or consume any controlled substance without a valid prescription. You can't have contact with Daniel Chavis. Are there any other conditions the state would request?
Your Honor, state would also ask for no contact with Mr. DeLon, Angel DeLon.
All right, no contact with any witness or co-defendant in this case. Do you understand that?
Yes.
Good luck. Please tell me your name. Sir, what's your name?
Joshua Harmon.
Are you okay, sir?
I'm kind of sleepy.
I'm sorry, I can't hear you. Can you get closer to the microphone? Leave your mask on.
Yes,
Are you-
ma'am. I'm kind of sleepy. I'm sorry.
Okay, but you're okay.
Yes, ma'am.
Okay. All right, sir, you have 2 warrants for your arrest. In 20 CF 6642, a warrant was issued for your arrest charging you with burglary of a structure and grand theft. Another judge has already found probable cause. I'll stay the bond at $2,500 on count 1, $1,000 on count 2. You can't return to Cricket Wireless. Then in 21 CF 2633, another warrant was issued charging you with burglary of a structure and criminal mischief. Again, another judge has already found probable cause. I'll stay the bond at $5,000 on each count. You're not allowed to return to BB&T at 5750 Silver Star Road or have contact with any witness in the case. Do you understand that?
Yes, ma'am.
All right, good luck, sir. What? I didn't say that, but I should have. In both cases, it'll be no contact with any witness. It wasn't on there, but. Please tell me your name. 21 CF 11771. Sir, you're here charged with burglary of an occupied structure and petty theft. I'm going to appoint an attorney to represent you in this case. There is probable cause. Your bond is $5,000 on count 1, $100 on count 2. You can have no contact with any victim or witness in this case. You can't return to
1100 West Colonial Drive,
Unit 5.
Unit 5.
Well, 1100 West Colonial Drive. Just don't go back to that whole place. Do you understand? All right, good luck. Please tell me your name.
Todd Reethy.
In 21 CT 5998, you're charged with driving while license suspended. There is probable cause, and I'll appoint an attorney to represent you. Your bond is $500 in that case. You can't drive without a valid Florida license. In 21 CF 11783, you're here charged with destruction of evidence, resisting an officer without violence, and 13 counts of possession of a weapon or ammunition by a convicted felon. Again, I'm going to appoint an attorney to represent you. Ms. George, did you wish to be heard?
Yes, Your Honor, on the destruction of evidence, I know it states that he allegedly threw a weapon, but I don't see any other facts that would suggest that there is any type of destruction of evidence.
State has no objection to it being an attempt, Your Honor.
That's what I thought too when I read it, Ms. George. I agree with you. So I do find that there's probable cause of attempted evidence destruction. On that count, I'm going to treat that one as a subsidiary. Your bond is $150. Resisting, your bond is $100. However, on 13 counts of possession of a weapon or ammunition by a convicted felon, your bond is $4,000 on each count. Give me 1 minute. He has a hold out of Lake County?
The statute reads firearm.
Oh, okay, so
They can charge it separately, but
that's different.
the same statute.
Yeah, all right. Good luck, sir. Oh, you can't possess a weapon, firearm, or ammunition, or any controlled substance without a valid prescription.
He has a hold for Lake County.
Right, he has a hold, but it's a child support purge. So it should have a purge amount.
There's an amount.
It's not in the system.
Can you see
So
the amount he has to pay? I don't know.
I don't have that.
I mean, either.
But what it means is you'll be held until you're transported to Lake County unless you pay the purge amount. Because it's child support, it usually comes with a purge amount.
I can speak?
You can say anything you want, but everything you say is being recorded and can be used against you later. So I can't change the Lake County hold.
Yeah, because I was trying to find out how much the purge was because I could pay it with the bond amount.
Right.
He said.
One more time?
778.
For the purge? Can I pay it here or I have to pay Lake County?
It has to be served on you first.
It hasn't been served.
Oh, it hasn't been served.
That's why you have
Once it gets served, then you can pay it and then you'll be able to bond out.
Yes, ma'am.
All right, good luck, sir. Please tell me your name.
Luis Antonio Viera.
21 CF 11770. You're here charged with tampering with physical evidence and possession of drug paraphernalia.
I had nothing on me.
Okay, I'm going to appoint an attorney to represent you. There is probable cause. That doesn't mean that you're guilty. That doesn't mean the state's going to file the charges. Right now, it's just a determination of probable cause, but there is probable cause here. Your bond will be $1,000 on count 1, $100 on count 2.
There's nobody to take me out.
I'm sorry?
There's nobody to take me out.
I can't hear you.
Nobody to come and take me
Oh,
out.
to bond you out?
No.
You'll have to talk to your attorney. Maybe they can find someone for you. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers.
I wasn't doing drugs. I was sleeping. I wasn't doing it.
Listen, I believe you. It sounds like you're saying you have some defenses. I believe you can have defenses.
They
But
arrest me
you're
for
going to
no
have to raise them at a later date with your attorney, okay? I'm going to take no action on his out on bond case. Good luck, sir. Please tell me your name.
Brianna Walker.
21 CF 11757. You're here charged with possession of heroin, methamphetamine, alprazolam, and hydrocodone. I'm going to appoint an attorney to represent you. There is probable cause in this case. Your bond will be $1,000 on each count. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand? Good luck. Please tell me your name. What's your name, sir? What's your name?
I don't hear real good.
Can you hear me? Okay. Is that better?
Oh, yeah, yeah.
All right. Please tell me your name.
Stephen Williams.
Thank you. 21 CF 11776. You're here charged with aggravated battery with a deadly weapon. There is probable cause, and I'll appoint an attorney to represent you. Does the state object to pretrial release?
Your Honor, if you're inclined to put him on pretrial release, state would just ask for bond in conjunction with pretrial release. He does have a prior VOP showing an inability to comply with court orders. And given it seems like the repetitive nature of potential issues between this defendant and this victim.
What says the defense, Ms. George, if anything? I don't know if you want to be heard.
I would just ask that you place him on pretrial release. It appears he does have community ties of over a year. He's on Social Security disability, and he has 0 failures to appear, which shows he will show up for court. Last conviction I'm showing was in 2015. So I just ask that you take all of that into consideration.
All right, sir, I'm going to place you on pretrial release and require that you post a monetary bond. However, I will reduce that amount significantly to $500. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
He keeps coming to my house.
I understand. Listen, you may have lots of defenses to this case,
I understand.
but you need to talk to your attorney about them. All we're doing today is I'm telling you there's probable cause. But this is not a jury trial. I don't even know if the state's going to charge it, okay?
Man hit me twice before I even done anything.
I read it. It definitely sounds like there are some issues here. But you can't have any contact with him.
I got no problem with that.
You can't possess a weapon, firearm, or ammunition.
I don't have any.
All right. Good luck, sir.
Your Honor, in regards to Mr. Akers, before he's brought back out.
Oh, from this morning.
Yes.
Good, I forgot.
I emailed and I wasn't able to get a response. I did get a number from our witness coordinator, but I got it about 10 minutes after you retook the bench, so I wasn't able to call him. Do you mind if I step away for 1 minute?
Wait, you got a number for who?
For the deputy in charge of this case.
Okay, go ahead, we'll take a recess.
Thank you.
I need to we're back on the record. I need to revisit one other thing. The tampering charge, 918.13, that statute does not include attempt.
So it's the original statute with the 777 statute.
That's what we need to add. So keep the same statute number. That stays, and then
So it's the original statute and then add
777.04.
04.
That's it. Now that's it. All right, thank you. Yes, Ms. May.
In regards, do you want to recall the case, Mr. Akers?
Yeah, I don't have it in front of me. Do you have the case numbers?
He was seen earlier for violations of probation, 17-03218, 17-07044, and 17-06793, all on-view violations of probation from the deputy. I did try to reach out to the said deputy to figure out if there was an affidavit for the PC that he found to file these violations of probation. I've not been able to get a response from him, given it's been a relatively short duration. I do see in the affidavit that his PC was the indecent exposure. However, I do not have that affidavit, and I do not see that affidavit. So at this time, state would just ask for a 24-hour reset to try to obtain it.
All right, I'm going to grant them the 24 hours because I'm confused by the affidavit too. It says an arrest affidavit was written, so I'm going to give the state 24 hours. All right, Mr. Akers, we're going to see you back here tomorrow. Actually, it'll be a different judge who sees you tomorrow, but I'm giving the state 24 hours to sort this out. If they're unable to, you'll probably be released tomorrow unless there's something else holding you.
That's the only thing, that's it.
Okay, all right, good luck. Now, is there anything else from either party before court is adjourned for the day?
Nothing from the state, Your Honor.
Nothing from the bench.
Thank you all.